the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, please be seated. Judge Young, we are particularly happy to have you with us today. It's a pleasure to have you.
Thank you. I'm glad to be here.
All right, let's begin with United States v. Gerald Johnson. Mr. Enzano.
Good morning, Your Honors. May it please the court. I'm Paul Enzina. I represent Gerald Johnson in this matter. And I'm arguing on behalf of Mr. Johnson and his co-appellants, Kenneth Jones and Marquise McCants. The centerpiece of the government's case against the appellants was its repeated assertion that the appellants had an ironclad rule that anyone who cooperated with law enforcement would be killed. And the jury was shown repeated evidence, which the district court characterized as gruesome, graphic, and shocking, of murders carried out against people allegedly because they cooperated with law enforcement. This evidence obviously affected the jury, which on multiple occasions sent a note to the district court saying that they were concerned and afraid of retaliation by the defendants. The appellants in each case asked the judge to ordeer the jurors to be sure they would remain impartial, but the district judge declined to do that, saying this is simply the reaction any reasonable person would have to this kind of evidence. That he said, who wouldn't be fearing for their own safety in this case? On the fourth such occasion, one of the jurors came into the jury room, and one of the other jurors described this juror as quote unquote freaked out. And he told the rest of the jurors that the defendant's family and friends were taking photographs of the jurors. The district court, as this court recognized, immediately recognized the seriousness of this allegation because, as the district court said, why else would anyone be photographing jurors if they weren't trying to intimidate the jurors?
Well, the district court took the matter seriously, and as I understand it, juror number 4 was removed from the jury and didn't deliberate. And at least after the remand, the district court polled the jurors and took testimony from the jurors. And the point made by Judge Motz earlier in her dissent was that the district judge is in the best position to appreciate the dynamics of a jury deliberation and to know the seriousness of the violation and what exactly could be done by means of instruction. And it's a very able district judge, and I'm hard pressed to see what the district judge did wrong.
Well, Your Honor, you're correct. The district judge did dismiss juror number 4. The district judge said this juror may well believe that something was going on in that regard. And if that's the case, that could affect or influence them in this case.
But he didn't just dismiss juror number 4. He polled the jury to see what kind of effect it would have.
Well, this court has already found that that was error. The way the judge handled the voir dire of the jury in the trial was error. And this court remanded it for a Remmer hearing. And the court did conduct that Remmer hearing here, and the jurors testified. What this court said was the problem that led to the dismissal of juror number 4 could apply equally to any other jurors who had heard the statement from juror number 4, even if they hadn't witnessed photo taking themselves. This court said other jurors had the same information as juror number 4 and reasonably could have reacted in the same way. So the district judge did conduct the Remmer hearing. And the problem was that this was a post-verdict Remmer hearing. And as this court has noted on numerous occasions.
Let me ask you, what is the district court supposed to do? The district court trying to comply with their mandate, and it took the testimony of the jurors and it asked them what effect, if any, did it have? Whether it would violate their right to be impartial, and it satisfied itself that a fair trial was held. I don't understand what else the district court was supposed to do here.
Well, the problem is not that the district court failed to do something it should have done. The problem is the district court did something it should not have done. And that is it violated Rule 606B by asking the jurors whether they could remain impartial and keep an open mind after this event. This court sent it
And
back.
why was that error?
Why was it error? Because Rule 606B very clearly says that a juror after the verdict is not competent to testify about their mental processes concerning the verdict. And what the judge here.
Why was asking that question, questioning their mental processes as it related to the verdict?
Because what the district judge here tried to do was quote unquote thread the needle by telling the jurors, don't tell me about what happened after deliberations began. Just tell me about what happened before deliberations began. The problem is, as the language of the rule itself recognizes, the jurors' mental processes concerning the verdict aren't limited to deliberations. Jurors hear evidence, they decide.
But the district court was trying to follow the mandate and to find out what effect it had. What is it? I don't understand what the district court could do. It tried to follow the mandate of this court in the most bona fide way that it possibly could. And I understand why you don't want, but it's interesting why you don't want that testimony from the jurors. You don't want that testimony because the testimony almost uniformly points in the direction of, no, this didn't have an effect on our deliberations. It wasn't a central part of our deliberations. It didn't affect my ability to be impartial. And I don't blame you for not wanting that testimony to get into the record, but it seems to me that the district court was just trying to do what exactly the prior opinion suggested.
Your Honor, it's not a question of whether I want the testimony or my client wants the testimony. It's a question of whether the testimony is permissible under Rule 606B. And what I would submit is that it is not.
Counsel, can I ask you, I mean, the judge asked the jurors a specific list of questions. It would be helpful for me, which questions did the judge ask that you believe violated Rule 606?
The questions that I believe violated Rule 606 were, I think they were numbers 9 and 10. Were you able to remain impartial? And were you able to keep an open mind?
And that's because those questions were not prefaced by the words before deliberations began, comma?
No, it's because the judge was not permitted to ask those questions by Rule 606B.
So one thing I was having a very hard time, I agree with Judge Young that, in the briefs that you sometimes shorthand the rule as saying their mental processes, but the rule doesn't say their mental processes. It says their mental processes concerning the verdict. And I was not able to find, the advisory committee notes do not really talk about this much at all. And I was not allowed to find a lot of cases saying what concerning the verdict means. What's your best authority for the proposition these questions were concerning the verdict?
My best authority are two cases, one in the Supreme Court, and that's Tanner versus United States, and the other is in this court, and that's Fullwood versus Lee. If you look at Fullwood versus Lee, that's a case where after the verdict came in, one of the parties to the case brought in an affidavit from a verdict. It was a death penalty case, and brought in an affidavit from a juror saying that one of the other jurors told the rest of the jurors that her husband was constantly telling her, you need to convict this guy and give him the death penalty. And that was both before deliberations and after deliberations.
Well, that's obviously concerning the verdict. That's saying someone said we should convict this guy because I agree. That's clearly concerning the verdict, but that seems like a couple steps away from, were you able to remain impartial?
Well, asking the jury if you remained impartial certainly concerns the verdict. I mean, that's the sine qua non of a juror. They have to be impartial. And to say to
But you said you wanted them to keep this out of their mind, correct?
Correct.
That's what you wanted the judge to ask.
yes,
But so can you tell me, because this is what I've been wrestling, what's the difference between remaining impartial, keeping this out of your mind, like you said, and keeping an open mind, like the judge said in all the transcripts I read? So what is the difference between those in the context of, I don't want to hear about your deliberations, but between the time that the photographs were taken or this photographic incident and closing argument, what's the difference between those three words?
well, the difference and what's important to recognize is the argument that I made about with respect to the judge not asking them if they could keep it out of their mind specifically is prefaced on the notion that this argument only comes into play if the court determines that 606B did permit this testimony. So it's an alternative argument, first of all. So they're not inconsistent for me to say that. What I'm saying is that if you're going to ask the jury, could you remain impartial? There were two obligations. One is you had to tell the jury what impartial means. It doesn't just mean considering all the evidence or considering both sides. It means considering only the evidence in the case. And a juror could have thought perfectly reasonably that they were being totally impartial. They considered all the evidence against the defendants and all the evidence for the defendants. And in considering the evidence against the defendants, considered the photo incident. They could have considered that to be impartial. But no one told them that, no, not
Excuse me,
at the trial.
if you think there was an error here, and I'm not, and I do not believe so, there still is a question of the harmlessness of it, because there was no external contact. Juror 4 was excused, and the district court said this was an uncorroborated allegation. They couldn't even find any evidence to support the allegation. And then in addition, the evidence here against the defendants was simply overwhelming. There's a mountain of evidence. And I'm wondering, given this, I mean, upending the result of a 10-week jury trial with more than 50 witnesses, 500 exhibitions, it would seem to me that the jury had quite a lot of evidence to rule the way that it did. And it's what you're asking is for a reversal on the basis of an uncorroborated allegation with no external contact, where the juror was excused, and you want us to overturn a 10-week jury trial with all of these different witnesses. You're going to have everybody come up again, given the strength of the government's case. I don't get it.
Your Honor, the fact that this court has already held that the fact that this was uncorroborated and the fact that may have been that no one actually did try to take pictures is irrelevant, because juror number 4 came in and told the jurors that that's what he saw. So that's beside the point, whether or not that happened. And as far as the tidal wave of evidence, I would point the court to Barnes versus Thomas, where the court said the inquiry is not the sufficiency of the evidence absent the error, but rather what the impact of the error on the jury's verdict. It does not matter how much evidence there is. If the jury is impartial, the verdict is invalid. If the jury is not impartial, the verdict is invalid.
But so, counsel, can I ask you, I see you as having two different claims of error that seem to be completely mushed together in the briefing. One is whether the jury was impartial. That's a due process question. One is whether the federal rules of evidence were complied with. That is a non-constitutional rule-based violation. So assume I think that the district court maybe violated Rule 606, but that nothing it did violated the due process clause. The remedy then, if any, is a new Remmer hearing, not a new trial, right?
Well, I don't think it is actually, Your Honor, because
on what basis would we overturn a 10-week jury trial in the guise that during the course of a post-verdict hearing, the district court violated the rules of evidence?
Well, the error here was not simply that the judge violated the rules of evidence in the Remmer hearing, but the district judge violated Remmer during the trial by not holding the hearing then.
And we sent it back for a new Remmer. I mean, the reason what got me thinking about this is that Remmer 2 itself was before the federal rules of evidence. And it looks to me that in the hearing contemplated in Remmer 2, there were questions that would violate Rule 606 if done post-verdict. And so, I mean, they're just different questions. One question is whether the due process clause was violated, whether the jury was impartial. And if the jury wasn't impartial, that's probably automatic reversible error. But if the only violation that happened is potentially a violation of the rules of evidence, I don't know why you would vacate the jury's verdict in that situation.
Because under Remmer, the Supreme Court has said that if there is that external influence like this, and I use the word external influence despite the fact that it was uncorroborated because of what this court has already held, but that is presumptively prejudicial. It is so damaging that it is presumptively prejudicial, and the government bears a heavy burden to show there is no reasonable possibility that a juror was affected. And given the problem here is that the district court violated Rule 606B, and without that violation, the government cannot meet its burden. I'm not arguing that the jury was in fact not impartial in this case, but let me. I only have a few seconds left, but let me leave you with this thought. The policy behind Rule 606B is to prevent harassment of jurors and to ensure finality of verdicts, because we don't want jurors being hounded after trial to come forward and say, well, I didn't approach the deliberations right. That policy, the government's view in this case would completely eviscerate Rule 606B, because what it would mean would be that a juror could come in and say, well, the day before the verdict, I did something.
Thank you, Mr. Nzana. You have some rebuttal time as well.
Yes, thank you, Your Honor.
All right, thank you. Mr. Martinez, we'd be happy to hear from you when you're ready.
Thank you, Your Honor. Good morning, and may it please the court. Peter Martinez for the United States. The record shows that there was no external contact with the juror in this case.
Can you speak up and put that microphone closer to you?
I'm sorry, Your Honor.
Yeah, that's much better. Thank you.
No one took, attempted, or threatened to take photographs of any jurors, nor did any deliberating juror or alternate perceive that such a contact had taken place. The jurors did not, as the district court wrote, provide substance to shadows. All that happened was this: one juror who was dismissed misinterpreted an everyday encounter with a woman holding a phone in a hallway. That encounter cannot be the basis for awarding these appellants a new trial. However the encounter is analyzed, whether this court applies a subjective test, an objective test, or both, as the district court did, there's simply no world in which this disproven photographing allegation impacted the verdicts in this case. In terms of precedent, Your Honors, the alleged encounter here was wholly different in character than the contacts at issue in the three leading cases where this court ordered new trials following Remmer hearings conducted by district courts. In two of those cases, Barnes and Stockton, the external contact happened during deliberations regarding the very matter the jury was considering, whether to impose the death penalty. In the third case, Cheek, the external contact was literally the abduction and attempted bribing of a juror. Here, by contrast, the allegation in this case is far more similar to the contacted issue in three other cases that have come before this court: United States versus Hines, Barahona, and Small. In all of those cases, jurors encountered people holding cell phones and speculated that those people may have been taking their pictures. In Barahona and Small, this court found that a Remmer hearing wasn't even required. In Hines, the district court did conduct a Remmer hearing, but it only questioned the juror who reported having seen an agent taking photographs, notwithstanding the fact that that juror discussed both the incident and the district court's instructions pertaining to the incident with his fellow jurors. In the opinion remanding this case, the majority pointed to Hines, and it said that the district court had failed to create the same kind of record here as to whether the jurors remained impartial. That's exactly what the district court did on remand. In fact, it did even better than the trial court did in Hines. Here, unlike in Hines, the district court dismissed the juror number 4, who made the photographing allegation. Unlike in Hines, here the district court questioned each and every juror and alternate, as well as the court personnel who witnessed and investigated this incident. And so given all of that, Your Honors, there's an even clearer record that the incident here was non-prejudicial than there was in Hines.
Well, Judge Heitens made the good point that we're dealing at most here with a violation of the federal rules of evidence. I don't see we're dealing with any kind of constitutional infraction. The question really front and center is an evidentiary question. In Rule 606B, and when you get into evidentiary questions, what to admit, what to exclude, where you're talking about evidence, and particularly a judge's handling of a jury. You're talking about something in which district judges deserve a certain amount of latitude. There just isn't any other way for the federal rules of evidence to operate. And even if there is a 606B violation, which I don't think there is because of the care the district court took in formulating it, but the district court was just trying to follow our mandate when he did what he did by asking about the effect, create the record. And it's the kind of thing that district courts are in the best position to manage, because the jury is not in front of us. We don't get to evaluate it. The district judge was the one that got to evaluate the dynamics of the trial and the responses of the jury.
I think that's right, Your Honor. And with respect to this court's mandate, I just want to come back to the conclusion in the majority opinion, which was, we reached the firm conclusion that the defendants were entitled to an evidentiary hearing under Remmer to determine whether all the jurors remained impartial throughout the case. Full stop. That was the instruction to the district court, and that's exactly what it did here. And it did so consistent with 606B. It told each and every juror who testified that it didn't want to hear about anything that happened, anything the jurors felt or thought after deliberations began.
Well, I looked at the questions, and I agree the district court had a very hard job trying to follow our mandate in a very delicate situation. The first, I think, like 10 questions are not prefaced by the admonition. I'm not asking about anything that happened after deliberations. So what about questions, I think it's 9 and 10, the ones about impartiality, which are not prefaced by before deliberations start? What do we do with those?
I think those questions were fair game, especially in light of the proviso that the district court gave the jurors.
What proviso?
That I don't want to hear about anything.
No. I looked at the format that the district court recited to the jurors, and there were a couple of questions that were not introduced by the proviso before deliberate. The court asks a bunch of questions, then it says, for purposes of my next questions, I don't want to hear anything. So what do I do with the questions that are before that proviso?
Well, importantly, Your Honor, I think the questions about impartiality and keeping an open mind were prefaced by that proviso. The remaining questions, the questions that came beforehand, I think were highly unlikely to raise 606B issues, and therefore the district judge didn't feel the need to give that proviso before he asked the question.
Can I ask you the question I asked your colleague on the other side? What is the best authority you're aware of what the words concerning the verdict mean?
Well, I think you start with the plain meaning of the rule.
Sure. Concerning is not exactly the most totally unambiguous word in the history of the world.
Sure, Your Honor. I think one common sense way to interpret the plain meaning of the rule is to think about what juries are instructed as a trial is taking place. Throughout this very trial, the district judge repeatedly admonished the jury to keep an open mind, not to discuss the case with each other, and not to begin deliberating upon a verdict until after all the evidence was in. The judge had instructed the jury and the lawyers had made their closing arguments. Those instructions and the way trials are ordinarily conducted, Your Honor, I think is my best authority as to what concerning the verdict means. It's a common sense proposition. We can also look at cases like Hines, Your Honor, where during a post-verdict Remmer hearing, the affected juror was asked, did this affect your ability to remain impartial? He testified that it did not. And this court considered that in finding that there was no prejudicial impact of the photograph.
Did we consider whether that violated Rule 606?
No, not squarely.
And that's the challenge I have. I mean, I agree with you. There are cases where we recite evidence that appear to be barred by the defendant's test. You say that about Cheek, you say that about Barnes, you say that about, actually, heck, Remmer 2. There are questions in Remmer 2 that seem to violate the defendant's test in this case. But I'm not also sure that in any of those cases, the court actually specifically confronted whether that, I mean, in Remmer 2, the federal rules of evidence hadn't been enacted yet. But in those other cases like Cheek, I didn't see us wrestling with whether that testimony complied with Rule 606.
I think that's a fair point, Your Honor. To the extent you do wrestle with Rule 606B in this case, I want to pick up on something counsel said in his argument, and that is the purpose behind 606B. Counsel's absolutely correct that the purpose behind the rule is to prevent the impeachment of verdicts and to prevent jurors from being hauled in after the fact and harassed with questions about things that took place inside the jury room. I would submit that once Remmer has been triggered and the presumption applies, and a district court is in the posture of having to get to the bottom of whether an external contact was prejudicial, the interpretation of Rule 606B that is most consistent with its purpose, which is to ensure the integrity of juries, is to give the district judge the latitude to ask questions that get to the bottom of whether the external contact prejudiced the jury. And 606B envisions that when it carves out a
Well,
universe.
so many of these cases did not involve the circumstance that we have here, which is a district court operating under a mandate from the Court of Appeals. And so the district court was operating under a mandate, and many of these other cases did not find the district court operating under a mandate. So you've got the district court is pinched in that one thing, and that it has to follow the mandate of the court. And the district court says, I'm going to strike a balance. I'm going to ask, in accordance with the mandate, what the effect of the allegation had upon them personally, but I'm not going to get into the impact on their deliberations or the course that their deliberations took. And so you have a district court trying to dutifully to strike a balance, working under a mandate, trying to satisfy the mandate, at the same time trying not to violate 606B. So I don't know what, given the confluence of all the circumstances here, I don't know what the district court was supposed to do other than what it did. I kept saying, well, how would I have handled this? Well, given the mandate, I would have tried to strike the balance. The district court did comply with the mandate, not violate 606B. And he navigated all of these conflicting currents pretty skillfully.
I completely agree, Your Honor. I think the handling of this hearing was the wise exercise of discretion. And I would add that had the district court not asked the jurors whether they could remain impartial and whether they kept an open mind, that would undoubtedly be an issue today, just as it was when we argued the case before a different panel 3 years ago. That was the key thing that the panel focused on in sending this back. The district court didn't ask the jurors whether it could remain impartial. And that was front and center in the opinion that remanded this case.
What if we determined that the judge did violate 606B? Then what?
I'm glad Your Honor asked
Sure.
the question. I was thinking about it when Judge Heitens asked the same question of opposing counsel. I would submit that the remedy isn't even a new Remmer hearing. I think the remedy—
I was saying at most it would be a new Remmer hearing.
Correct, Your Honor. I think the remedy is just to not consider the inadmissible testimony if the court finds that 606B was violated. If those questions violated the rule, you're still left with the objective analysis under the Basham factors, all of which tilt in our favor. You have the fact that the jurors hardly discussed this incident on the day it occurred. I think you can find from the record the district court found that their discussion of this incident lasted a couple minutes at most, and that importantly, after the district court instructed the jury the following day that the matter had been investigated and no photographs had been taken, the jury didn't talk about it again after that. You also have the fact that this was a fleeting encounter. It didn't provide the jury with any extra record information about any relevant substantive issue in the case. You have the timing of it. It happened 2 weeks before deliberations. It was followed by 2 different curative instructions. The instruction the following day that no photographs had been taken, and then another instruction after closing arguments in which the jurors were told not to consider anything they may have heard or seen outside the courtroom and to consider only the facts and evidence. You also have, and Basham expressly directs courts to consider this factor, the weight of the evidence, which was simply overwhelming in this case. A parade of cooperators put these defendants in the Black Guerrilla family. Multiple witnesses testified that appellants Johnson and Jones committed murders and shootings. Appellant McCants himself admitted to committing murders and shootings. And all of that evidence was corroborated by forensic evidence, cell phone evidence, social media postings, the defendant's own statements while testifying in their defense. Simply put, Your Honors, this was not a close case. So even if the court finds that Rule 606B was violated, it can still consider all of those objective factors, which have nothing to do with the jurors' subjective responses about whether they could remain impartial.
And what about your friend on the other side in terms of objective factors? I mean, there's sort of I realize they don't raise any claims of error about it that are specific, but the entire atmosphere of this, that this jury might that any reasonable juror sitting on this jury might be, shall we say, more jumpy than the average juror about the possibility that someone might be trying to influence them, given the nature of this case. What would we do with that?
I think that's a dangerous proposition, Your Honor. That position is essentially that these defendants were so prolifically violent that a juror couldn't pass a woman holding a phone without becoming constitutionally tainted. I think to the extent that the jurors reacted to the valid and admissible evidence that these defendants were guilty, that presents no issue under Remmer. The strength of the government's case, the graphic and gripping nature of the evidence, so long as it was lawfully admitted, that cuts only one way, and that's against a finding of prejudice. As the district court put it, the appellants can't bootstrap valid evidence of their guilt into invalid prejudice. I think that's clear under the law. I want to make sure to emphasize to the court the systemic interests that are at stake here. 3 years ago, in the small case that I referenced earlier, Judge Wilkinson wrote that it's difficult to fully shield juries from the outside world. And long before that, in Smith versus Phillips, the Supreme Court held that due process doesn't require a new trial every time a juror is placed in a potentially compromising situation. If the court reverses here and orders a new trial, it'll effectively be telling district judges that juries must be shielded from the outside world in a way that's neither reasonable nor practical, and that even de minimis disproven allegations can derail a criminal trial. That'll make it harder to hold public jury trials in criminal cases. It'll give defendants the power, as Judge Motz noted in her dissent from the opinion remanding this case, to demand new trials for what we ordinarily would consider innocuous conduct. That's not theoretical, Your Honors. If the court reverses here, future defendants in Baltimore and elsewhere will instantly realize that if the trial isn't going their way, they can get a mistrial, a hearing, a new trial, simply by enlisting associates and fellow gang members to stand in hallways and to display cell phones. We'd ask the court to avoid that here and to find, as the district court did, that there was no constitutional violation. If there are no further questions, I'll see the remainder of my time.
If either of my colleagues have any further questions, they're certainly welcome. We thank you very much, Mr. Martinez, and Mr. Inzana, you have some rebuttal time.
Thank you, Your Honor. Let me begin where Mr. Martinez left off. And he said, if the government reverses here, defendants will know that they can, what he said in his brief is, pull the proverbial fire alarm by enlisting their colleagues to go and take pictures of the jury or pretend to take pictures of the jury. Now, of course, the response to that is, if that happens during the trial, the court can and should, as the district court should have here, hold the Remmer hearing during the trial, which is when the court can ask the jurors, are you able to remain impartial? Now, consider the flip side, though. Suppose that this case we're here in a different posture. Suppose that instead of the juror coming in and saying and telling the other jurors that this happened, suppose he didn't say anything to the rest of the jurors. But suppose that after the case, the defendants, after they were convicted, came in with an affidavit from that juror. And he said, on that particular day, I saw somebody who I thought was taking pictures, and it freaked me out and made me so concerned. That was all I could think about. And I'm not talking about my deliberations here, but during the time that all that evidence was being put on, all I could think about was how dangerous these defendants were and the threat it posed to me. If the court allows what happened here to go forward, then there's no way to distinguish scenario I just put.
But your hypothetical is not our case.
No, it's not, Your Honor.
Not our case.
But the rule that's established in this case is going to apply in future cases. And the question is, as Mr. Martinez says, this case is going to send a message to future defendants. And what's that message going to be? And if the message is, hey, you can't bring a juror affidavit in to say, I don't see that there's any broad rule that this case is presenting. It's presented with a particular set of facts into which the district court inquired and found that it didn't have an effect on the fairness of the trial. But that's not a broad rule of any kind. This is a case by case inquiry, and that's what we have a trial court for, to examine all the circumstances and what it can and can't do under 606B, and ask whether there was an unfair trial. But I don't see this as generating any kind of broad rule. I see it as a very fact-specific case. Of course, it generates a broad rule, Your Honor. The rule is that the language in Rule 606B that says a juror cannot testify about his or her mental processes concerning the verdict does not apply prior to deliberations. And that rule will be the rule in every case going forward. And I submit that this hypothetical scenario I posited can't be distinguished from this case under that rule.
So I have a quick question for you just before, since you're running out of time. I'm still not clear on the answer to my question, which is, you said he should have said, that the judge should have said, can you keep this out of your mind? So just very narrowly, what is the difference between could you remain fair and impartial? Could you keep an open mind versus what you wanted him to say, which is keep this out of your mind? What is the difference?
There's a big difference because a couple of reasons. One, as I said, impartial doesn't simply mean considering both sides. It means basing the decision only on the evidence presented to you in the trial. That's not conveyed to the jurors in the ordinary meaning of the word impartial. Second, asking a jury, were you able to remain impartial, puts the juror on the spot, because jurors have a duty. They swear an oath to be impartial. And you're asking the juror, did you comply with that oath?
But he also said in the transcripts, did you keep an open mind? And you said you wanted him to keep it out of their mind. So what is the difference between these two?
I think the difference is because an open mind is the same thing as impartial. I have an open mind if I consider all the evidence, including that photo incident. That's an open mind. But what the rule requires is that the jurors, if you look at Irvin versus Dowd, the court says a juror has to lay that aside. And this is what courts do all the time in voir dire. When they're picking a jury, a juror comes in and says, this is a drug case. My son was jailed for drugs. And the judge will say, well, of course, all jurors come here with experiences and memories and so on, but can you put that out of your mind and decide this case only on the basis of the evidence before you?
But I'm not sure that example helps, because in that situation, we're not suggesting that the person literally forgets that their son was injured in a drug deal. They can't do that. That's not how the human brain works.
Of course. And that's the problem here, that the district court and the government both reduced that inquiry to the question whether or not the jury could remember it. And we never said that the juror couldn't be impartial if they remembered it. The point is that jurors have to be able to lay it aside, put it out of their minds, decide the case based only on the evidence. I see my time is up.
All right, thank you very much, Mr. Anzano. We appreciate it.
Thank you, Your Honors.
And I think we're preparing to have a telephone conference. We'll do that, and meanwhile, we'll ask the courtroom deputy to prepare the courtroom for our next case.
The court will take a brief recess. Judges of the United States Court of Appeals for the Fourth Circuit.
All right, please be seated. Mr. Polston, we're happy to hear from you.
Thank you. Good morning, and may it please the court, Mark Polston for appellant. Your honors, in 1997, Springs Memorial Hospital provided medically necessary inpatient rehabilitation services to 227 Medicare beneficiaries. Those 227 beneficiaries represented 94% of all the patients at Springs Memorial Hospital would see that year in that rehabilitation. Those 227 patients had an average stay 23 days. That's 23 days of intensive rehabilitation physical therapy for significant illnesses and injuries provided to the Secretary's beneficiaries. The Secretary's position in this case is that he is not responsible for paying for 1 penny for any of the care provided to those 227 beneficiaries. He takes that position even though he is now recognizes that he is responsible for care provided to his beneficiaries in 1998 through 2000 under the same contract that Rehab Care entered into with Springs to provide services. Now, the Secretary doesn't take the position that the costs that Springs paid to Rehab Care in 1997 were somehow out of line with the cost that Springs paid to Rehab Care for 98 through 2000. Can't take that position because that's not supported by the record. Nor does the Secretary take the position that the scope of the contract in 1997 somehow was different in terms of the scope of services. Can't take that position because that's not true. It's the same contract under which rehabilitation services were provided for this entire 4-year period. And finally, the Secretary doesn't argue that the cost that Springs paid to Rehab Care in 1997 somehow are out of line or out of whack with the costs that other providers paid for the very type of same services provided by Rehab Care. In fact, that's not what's reflected in the record. And the cost that Springs incurred was within 8% of the cost of what were incurred by another hospital under a similar contract providing the same services, and that hospital was Toomey. Your honors, in this case, the Secretary's position is that he should receive all of these free services for free for his beneficiaries because of one simple fact, that Springs Memorial could not provide one piece of documentation that was requested for at the first point of time was when it was requested during audit. Now, the Secretary—
Counsel, you challenge the validity of 42 CFR 413.24C. This is the provision that requires that you submit information capable of being audited. Do you contend that that's an invalid regulation?
Absolutely not, Your Honor. It's a valid regulation.
Okay. And the Secretary concluded then for 1997, you did not submit information that was capable of being audited, right?
Well, that's the Secretary's conclusions, and their, our position, of course, is that they're legally informed.
Well, do you contend that they were in fact capable? But do you contend that the Secretary you exceeded his discretion in concluding the information you gave him in 1997 was not in fact capable of being audited?
Yes, Your Honor, we do. There are a number of reasons. First, that regulation does require all providers to maintain documentation that can be audited. That same regulation goes on to say that auditable documentation is a type of documentation that can establish the fact for which the purpose of the documentation is intended. And the documentation that was provided here, the purpose that the Secretary wanted the payroll records that we were referring to was to determine the amount of services that were provided in 1997. So that's the intended purpose. There are other documents that were provided in the record, that are demonstrated in the record that will establish the very same fact. So, for example, the provider brought forward documentation regarding the provider statistical and reimbursement report, or what's called a PSNR report. That PSNR report is the Secretary's own documentation. The Secretary uses the PSNR report to actually audit other hospitals' cost reports every year. Now, that PSNR documentation would have established and did establish the number of units of service of physical therapy that Springs provided through rehab care in 1997. The reason that the secretary insists upon the payroll records is to understand and is to determine the number and the volume of units of physical therapy provided in 1997. So the district court reached the conclusion that it was impossible for the secretary to utilize the documentation that was provided. That's clearly an error. That's not supported by the record. The district court's conclusion that it was
Can I ask you about
impossible.
another provision? I mean, it's a striking provision. This is 42 USC 1395GA. Now, so basically, I just heard you explain, and I'm not an expert in this, and I just heard you explain why you think the information you gave them is good enough to let them do what they want. And I expect that your friend on the other side will get up and tell me why it was not good enough to let them do what they want. And candidly, sitting here, I have no way of knowing how I'm supposed to figure out whether it was enough. But then I look at a statute that says, you said the question presented is the secretary wants services, but he doesn't want to pay for them. But this statute says no payment shall be made, I gather, to anyone until the provider has furnished such information the secretary may request in order to determine. I mean, that's a pretty sweeping grant of authority to the secretary to decide what information they deem sufficient. So why isn't just that? Why are you not just right that you gave them enough information, but you're so right that their contrary determination doesn't fall within the statute, which seems to give the secretary pretty sweeping authority to decide what he thinks is necessary?
Your Honor, there are three responses to that question. The first response is that while the secretary can demand documentation, the secretary cannot demand irrelevant documentation. And the documentation.
And we're supposed to make a de novo decision of whether something is relevant or irrelevant under the Medicare statute?
Your Honor, you can interpret the law, and that's what the district court failed to do. The law establishes that the secretary has to pay a reasonable cost for these services. A reasonable cost has a definition. It's the costs that are actually incurred minus any sort of costs that are unnecessary in the delivery of services. And Secretary's regulation also recognizes that those costs from provider to provider may vary from time to time. It also recognizes that what the primary definition of reasonable costs is those costs cannot be, they're reasonable so long as they're not substantially out of line. The Secretary interpretation of that regulation, which is unquestionably applicable here, Secretary's interpretation of that regulation is set forth in his provider reimbursement manual at section 2135. The documentation requirements that he requires under the statute that you cited, 1395G, the documentation requirements that he put Springs on notice of are set forth in 2135. And the
Why wouldn't, let me ask you this, counsel, why wouldn't auditable payroll data be one of the essential parts of information that the secretary would want to find out whether the requested reimbursement was reasonable or whether it was out of line? I mean, all you offered initially were rough estimates of salary and bonuses or what have you, but that isn't any substitute for the actual records and for auditable payroll information. And the payroll data is one of the things that accountants go to first. And that shows you an awful lot of people, an awful lot, and it shows you whether they hire too many people, and it shows you what they what they paid them. And you get to compare those figures, and I mean, I'm sort of perplexed because I don't understand how the secretary can do its job as a guardian of the public fisc under the statutory mandate that Judge Heitens just read to you, which does, to use his words, seem to me to be sweeping. And given the way in which healthcare costs are just rocketing upward, there has to be some check on them. And if you disable the secretary from getting auditable payroll data, doesn't that communicate to healthcare providers that they can be sloppy in the way that they're going about things?
Your Honor, there are two primary responses to your question. First, again, the question here is what was the purpose for which the secretary sought those payroll records? He did not, as your question implies, seek those records to determine how much rehab care paid to its employees. That's an irrelevant question under the reasonable cost standards. What the secretary required those documents for is he wanted to apply what's known as the therapy cap. The Medicare statute places a cap on the amount that providers can seek reimbursement for when they purchase or contract out for those therapy services. The secretary, that cap is applied through the cost report that a hospital completes. That cap is applied by using units of service, hourly units of service. And the secretary, in this case at audit, wanted payroll records in order to determine the number of units of service. Those units of service are then multiplied by an hourly rate, and he used that to determine whether or not he wanted to use that as a proxy to determine whether or not the therapy cost portion of this contract was reasonable. Remember, this
But I'm not, again, you not only have the statutory mandate to contend with. I was reading the regulation 413-24C to say that you all had an obligation to provide, quote, adequate data capable of being audited. And why wouldn't the auditable payroll records fall right in the heartland of what the regulation in 413-24C says that the secretary is entitled to ask for?
Your Honor, the regulation goes on to say you can auditable documentation for the purpose for which it is intended. Again, the payroll records here, by the secretary's own admission, were only intended to be used to find the number of hours of units of service provided in 1997. Your Honors, that is not the only documentation that's available in the record to determine that. Springs Memorial carried its burden to bring forth auditable documentation when it brought forth the secretary's own PSNR data. Springs Memorial carried its burden when it came forth and showed the medical records. The medical records could be utilized to determine the number of units of service. That's the only purpose, Your Honor, that the secretary wanted to pay.
Well, but it seems to me that this case is the purpose you're talking about a contract that you have, and the contract covers two different things. One, patient therapy services, and the other are management services. And that probably brings up two different kind of considerations, but they want to know in each of these, did you hire more people that were necessary? Did you pay them an exorbitant or an unnecessary salary? So the fact that you're dealing with a contract for two different kinds of health services would seem to me to indicate the value in having auditable payroll data to get a precise idea of whether the government is being charged an excessive amount.
Your Honor, again, in response to that question, the secretary's own manual guidance explains exactly how to determine the reasonableness of a contract, exactly the type you're talking about. This was an all-inclusive contract. The secretary, it provided for both management services as well as therapy services. The secretary, in an attempt to determine the reasonableness of the contract, asked the provider to split those fees out into management fees as well as into therapy fees. That was done through the documentations in the record, the value quantification. The secretary, and again, Your Honor, this is a very important point. The secretary was not attempting to find out whether or not Springs Memorial paid too much or rehab care paid too much.
Sir, I think you
Certainly.
made that point earlier, and I understand that point. In other words, this isn't what you're arguing about is what the purpose of the secretary's questions are, right? And if they don't have the purpose that you believe the purpose for information the secretary was looking for, that it's irrelevant. But the regulation says no Medicare payments shall be made to any provider unless the provider has furnished such information as the secretary may request. So it seems to me that the secretary can request it for any purpose that he wishes.
Your Honor, I see that I'm going into some of my rebuttal time.
Right,
so I'd
and
like to
if maybe
finish.
if you could just answer that
I
question.
will answer this question.
Thank you.
That regulation does not entitle the secretary to ask for irrelevant documentation, and that's what the secretary has done here.
Okay,
I
and
would-
so if we should determine that it's not irrelevant, then you lose, right?
Your Honor, if you determine that the secretary needed this information and there was no other evidence,
No.
there's no other evidence in the record that would support the secretary's purpose, then we would lose. But I submit you cannot find that on this.
So what is your position if there was another way for the secretary to determine it, he couldn't ask for this information? That can't be the way you read. If he could use this information to do what he wanted to do, he's entitled to ask for it.
Your Honor, if he can use that information, but there's another provision in the Medicare statute that we haven't talked about. And that's the reasonable cost provision of the statute. It's also in the regulations. And that sets forth a principle. It's known as the cross-subsidization principle. And that cross-subsidization principle tells the secretary that in applying the rules to determine reasonable cost, the secretary cannot act in a way that would shift the cost of services to his beneficiaries onto others. That is a command from Congress. And Your Honor, I'll
All
just
right, thank you, counsel. If my colleagues have any questions, I'm happy to defer to them. Otherwise, we'll just wait and hear from you on rebuttal. All right, thank you. We're now prepared to hear from the secretary. And Ms. Lopez, it would be a pleasure to hear from you.
May it please the court, Carolyn Lopez on behalf of the government. With the court's indulgence, I think it might be helpful to take a step back to talk not just about the sweeping authority that the secretary has, which we absolutely agree that, you know, that authority says no payment shall be made unless that documentation is furnished, but also to give a sense in this record, we do take issue, as Judge Heitens mentioned, we might with whether or not separately this documentation was relevant. And so here we can tell why the missing 1997 payroll and salary data is critical because of what happened in 1999 and what the board said.
Well, I was going to ask you, why is this period stood out in a group of periods? Was the same information provided to you in all the periods?
No, Your Honor. So 1997 is a loan, and the district court recognized this as well. And of course, this was the board's explanation. 1997 stands distinct from 1998, 1999, and 2000 because in those cases, the provider actually was able to provide the payroll data. And again, as Judge Wilkinson was saying earlier, not only is payroll data an incredibly normal accounting tool that every business has, but actually, as we discussed in our brief, section 2304 of that same manual that we've been discussing today expressly lists payroll data as the type of data that every provider has to have on hand and be ready to furnish to the secretary. And that's that provision goes to what is the type of adequate documentation listed in 413, described in 413-24C more generally. And in terms of what happened in 1999, so the secretary absolutely, the contractor and then later the board absolutely did not only look at the payroll data to figure out the volume of direct therapy services. That's something that comes up in the reply brief here. Instead, what happens in 1999, which the board discussed at JA 48 through 49, and that settlement decision is at JA 96 through 97, is what happens is when the plaintiff actually breaks apart these bundled costs, so it's both direct therapy costs and also management and administrative costs. When they break that out into this model, and they provide the payroll data, the contractor was able to use that payroll data to actually determine that a portion of that 1999 cost was not reasonable. And the hospital didn't appeal that determination. And so the board says, and then the board says on appeal, they gave them another chance to provide additional documentation. And on appeal, the hospital was able to provide similar documentation for 1998 and 2000. And the secretary says, now that we have that information, we'll remand to the Medicare contractor because now they can do that analysis to figure out. And again, and this is at JA 51 through 52, to determine what portion of those costs are reasonable. And without, this is exactly why Congress wrote the statute that way. Without that type of proper documentation, the secretary can't, especially in costs that sort of bundle a lot of different things together into one thing, the secretary can't untangle those costs and actually determine what portion is reasonable and what is not.
Ms. Lopez, can I ask you what strikes me as the hardest problem for the government, which is there doesn't appear to be any dispute that this entity actually provided some services in 1997. And I get the government's point, we don't have some of the information that we need, and your point about 1999 is very astute, but what you said there is getting this information allowed us to reduce the amount they get, not eliminate it. And so I totally understand the argument this means they get less, they need to take a haircut, maybe even a very big haircut, but it does seem pretty harsh to say that because they don't have this information for 1997, an entity that conceivably provided a bunch of reimbursable services gets zip. Could you help me with that a little bit?
That is what the statute says. So the statute is section 1395 GA. Congress has weighed sort of the costs and benefits of saying without adequate documentation. One option would have been to say the secretary should sort of estimate how much is reasonable and how much is not. That's not what the statute says. What the statute says is no payment shall be made unless the documentation is provided. And there are, as we discussed in our brief, 6 circuits have held that that is an appropriate basis for disallowance. I think one of the most, there are 2 cases that I think are particularly instructive. So that's the 7th Circuit's Davis case, which we discussed. And the Davis case actually, interestingly, also involves the provision of therapy services. And the 7th Circuit there said, there's no question that some services were actually provided, but there's also no question that they didn't provide, that the hospital there, which was contracting out for those therapy services, just like here, didn't actually provide the timesheets that were required by the provider manual at that point, and that was a basis for disallowance. And Davis, to go to the sort of cross-subsidization point, also says that because that's Congress's chosen enforcement mechanism, it can't simultaneously be Congress's chosen enforcement mechanism for not maintaining.
But is it still open to the healthcare provider to submit auditable payroll data, or where is it? Has it just been lost? What? Is it still open to them to submit a claim for reimbursement by providing auditable payroll data?
At this point, they have not in their briefing or to my knowledge.
Could you get
Sorry,
to-
I turned to, my apologies. In an effort to turn more towards you, I turned away from the microphone. To my knowledge, they haven't ever offered the payroll data. At most, they've said in the briefing that they chose to have the contractor have it and that they don't have the data.
But would it be open to them if they now offered auditable payroll data to get reimbursed or to get paid, or is there some kind of informal or formal statute of limitations in terms of providing data?
My apologies, Your Honor. I'm not prepared to answer that question because it's never been suggested that they have the payroll data. What I'll say at a very general level is that there is an importance to sort of finality of the board's decision. They were given multiple opportunities, both before the Medicare contractor and on appeal. As I was just discussing, they were able to, on appeal, submit adequate payroll documentation for those other years. I would assume that if they had that payroll data, they would have offered it at one of those multiple junctures, but I can't get out ahead of the secretary as to whether
So in terms of finality, I don't know if this is legally relevant, but it is something that struck me why are we still debating reimbursements from a quarter of a century ago? I mean, is this normal? And if It just struck me that we're debating whether they provided adequate documentation for services they provided a quarter century ago.
So yes and no, Your Honor, that as both parties discussed in their brief, Medicare has now moved primarily towards a prospective payment system. So sort of now this isn't you, there's still a couple sort of holdouts of this reasonable cost methodology, but so it's a different way of looking things on the prospective payment system, but also just, you know, of course, the audit started much closer to when they actually submitted the documentation. And some of the reasons that you sort of have these long runs is precisely because there's a lot of back and forth, both with the Medicare contractor saying, I don't think this is enough, I need more. Can you provide me more and give me opportunities? Of course, the board process, which did include a full board hearing, and then, you know, this litigation before the district court. I'll say that, you know, some of the other cases that I was looking at, for example, the Davis case is 10 years later. So it's not, I mean, this is a long case, but it's not sort of completely out of the norm, that just that sort of precisely because there's so much process given and so many opportunities to provide the requested documentation, it sometimes kicks these out pretty far. But of course, as soon as they were being audited, they were, I mean, as we discussed, they were actually on notice from 2304 and just sort of ordinary accounting principles that they should have this payroll data. But certainly once they were being audited, they were well on notice to that they should maintain that during the course of.
Is this a fairly frequent occurrence that firms fail to submit auditable payroll data? Is this a recurring problem?
That's a great question, Your Honor. I apologize. I don't have sort of statistics. I mean, we know by the fact that 6 circuits have already addressed this question over the course of the years, and all those 6 circuits have said that failure to provide documentation is a basis for disallowance, that it is something that does happen. And it's certainly something that Congress contemplated happening in that section 1395 GA. I wanted to make sure that I answered all of Your Honor's questions, and also that I sort of wasn't leaving anything on the table in terms of things that may have gotten that in which the parties may disagree. I guess the one other thing that I'll say, and of course I'm open to additional questions, but the one other thing I wanted to say is to just talk very briefly about how that 2135 provision works, which has to do with contracts that bundle things. So as we discuss in our brief, so first of all, that provision actually doesn't apply directly to contracts like that. That provision, as per the title of the provision, applies to contracts that are that combine just management and administrative services, not the provision of direct care. And then second of all, you know, even assuming that provision applies, and the board did apply it by sort of analogy here, it absolutely does not cabin that sweeping discretion to ask for any documentation that is needed. So at 2135.3, the provision does say that under certain circumstances, when certain types of documentation is not available, the contractor has to ask for additional documentation. But of course, that doesn't prevent them from asking for additional documentation in other courses. And 2135.F specifically says that they are entitled to ask for any other documentation available which would support the reasonableness of the fees paid. And as we've just been discussing, payroll data is precisely that sort of data. And I think that that's, this reminds me that there was one other thing that I wanted to make sure to clarify, which is that it is categorically false that the secretary said that the costs weren't substantially out of line for 1997. That's at JA 49 and note 24. The board specifically found that the 1997 costs were substantially out of line. And at note 24, the board explained that that was actually based on plaintiff's expert own testimony. So plaintiff's expert said, after you take out a bunch of things and adjustments that we think explain why the costs are higher. So that's that Medicare mix and number of days that plaintiff's counsel is talking about. Even after you're making those adjustments, so this is at JA 124 and 125, he says that starts to bring these 1997 costs more in line with the state, i.e. sort of more substantially in line. But it doesn't actually explain that, but you'd still have, I want to make sure that I'm quoting exactly, but then this open question about the salaries in 1997 would remain. And at JA 114, that same expert says, I don't have any visibility on what would cause that 1 year uptick in the salary line, nor an explanation for what drove that higher. And that goes precisely to Judge Wilkinson's earlier questions about payroll. What payroll helps you do is figure out if it looks like something is sort of out of line in a particular year. It's not enough to sort of say our total costs were fine. And again, here the secretary found the total costs were not fine, but the secretary is also entitled to pull apart bundled costs like that and figure out whether certain pieces are reasonable or not. And Congress has determined that no payment shall be made if the secretary requests relevant data to that question and doesn't get it. If there are no further questions, we'd ask that for affirmance on the briefs.
Thank you, Judge Motz, Judge Heitens. Do you all have any further questions? All right, thank you very much. You have some rebuttal time, Mr. Poston.
Thank you, Your Honors.
Mr. Colson, before you get into it, it just keeps bothering me. Why don't we have the data for 97 that we have for these later years?
Thank you for asking that question. It's not from any reluctance of the provider to bring that forward. It's not because they didn't attempt to try to get that information. Remember, this was a subcontract with its provider, Rehab Care. It asked for the documentation from Rehab Care, and Rehab Care would only provide the documentation that we have, which was the hourly, the payroll records for 98 through 2000. That's the contractual relationship between Springs Memorial and Rehab Care ended, and they were essentially powerless at that point in time to get additional documentation. That's why they pivoted, Your Honor, to doing what they could to provide other forms of auditable documentation to the secretary. It wasn't from reluctance. It wasn't because they didn't believe that it was irrelevant and they just wanted to provide other information.
But I'm still uncertain as to who has this information. Is it Rehab Care or is it the hospital?
The hospital contracted with Rehab Care. Under the terms of the contract, Rehab Care would have been required to provide documentation to support its services. Rehab Care could have and should have kept that documentation, but Rehab Care failed to provide.
Did Rehab Care just lose the documentation?
Under that information is not in the record, and I would only speculate to say that Rehab Care lost the information. It wasn't available.
Well, then isn't your cause of action against Rehab Care?
No, Your Honor, because again,
Well, if you're not able to get reimbursement here, and you claim that you could if you had the correct records, and Rehab Care will not give you those records, I don't know why.
with all due respect, Judge Motz, I think I want to return to two quick principles that I think respond to your question. First question is, the secretary does have the authority you suggest to ask for documentation. Again, the secretary should ask for documentation to support the purpose for what he is trying to look at. The purpose that he was looking at here, again, was to determine the hours of service. The 1999 settlement that my opposing counsel referenced shows you exactly how the secretary used payroll records. He used it to determine the volume of therapy services. He plugged that number into his cap for therapy services, and he determined that in that year, all of the therapy services fees and the component of the contract attributable to therapy services was reasonable. Going back to the point that Judge Heitens raised about the cross-subsidization principle, at a minimum, that requires a secretary here to go through the same exercise. Because if the secretary doesn't look at the documentation that was provided that would show the number of units of services of therapy, do exactly what he did and satisfied himself as to the reasonableness in 1999, then the secretary is willfully ignoring the command of Congress to not shift those costs that he can and could determine the reasonableness of to other payers.
Ms. Lopez, excuse me, counsel, Ms. Lopez suggests that adopting your position would put us into conflict with 6 other circuits. Isn't this an area where, if she's correct, isn't this an area where a certain amount of uniformity, it's a national program and there are health providers all over the country, why would we be an outlier in this whole area?
Our position is not inconsistent with those 6 decisions. In fact, it's consistent with those 6 decisions. Those decisions certainly stand for the proposition the secretary has the right to request documentation. None of those decisions say that the secretary can request documentation that is not relevant to the inquiry. And that's the payroll records. While the secretary used them in one method to determine reasonable cost, he has other documentation. The last point I would like to make, Your Honors, and we barely touched upon this, is Section 2135. Section 2135 of payroll records were relevant to the inquiry determining the reasonableness of this contract under Section 2135. They would be listed in that documentation requirement. But if you go through the documentation requirements of 2135, you'll see no reference to payroll records. And Your Honors, the reason for that is that a contract like this, an all-inclusive contract, again, under the principles of 2135, to determine whether or not they're reasonable, you look to see whether or not the cost of that contract are in line with the cost of other contracts that are, if they've been competitively bid, or other indicia of reasonableness. And the evidence in the record is.
All right. Thank you. Thank you very much.
Wilkinson, can I ask one question? This is
No,
on-
absolutely. You sure can.
so you don't have to talk so fast. Somebody as feeble as I am can then hear it. So I take your position to be that even though it says no Medicare payments shall be made to any provider unless the provider has furnished such information as the secretary may request, is not an ironclad rule. And what you have to do is to look at the purpose for which the secretary is requesting the information. And if you give the secretary information that serves the same purpose, then you have not violated that provision of the statute. Is that correct?
That is correct. Secretary has.
So where do we find that purpose amendment to this, if you will?
Well, Your Honor, I think we cited some cases in our brief.
It's not in the statute.
Well, it's an interpretation of the statute. It's an
But
interpretation.
there's
of
no
that
statutory
regulation.
language that says that.
Well, Your Honor, the regulation goes on to say, the regulation in, the language in the regulation does go on to say that the secretary can request auditable documentation. That is intended, that proves, I'm kind of stumbling on the language, but basically that is designed to prove the purposes for which it's intended. That is the irrelevancy doctrine.
Well,
They've asked
I
for your
thought-
relevant
yeah, I didn't know that you made the argument, so please do tell me that this information would not satisfy the secretary's concern. I thought what your argument was, there's other information we provided that satisfied the secretary's concern.
If I may, I understand I'm running out of time, but
You've run out of time.
Yeah,
Talk quickly.
our first argument is that all of this documentation is irrelevant because the reasonableness of an all-inclusive contract for management services, which, contrary to what my opposing counsel says, can also include therapy services. It says it right there in the manual. The reasonableness of that is determined under very different principles. First, you look to determine whether or not it's competitive.
If you don't want to answer my direct question.
No, I'm sorry. I believe I did.
Okay, thank you.
Thank you very much. We'll take a 5-minute break and then we'll head right into our next case.
Court will take a brief recess.
All right, please be seated.
What happened?
Mr. Lieberman, I think you're first up here, or
Wilkinson, we're still waiting for one attorney to return.
You don't dare let them out, Judge Wilkinson.
Eventually.
He'll never come back. Man who never returned.
We're ready for you.
Good
all
morning.
right, Mr. Lieberman, whenever you're ready.
I'm ready. Good morning, Your Honors. Jeremy Lieberman, Pomerantz LLP, on behalf of appellants. Your Honor, plaintiffs submit that the district court committed a reversible error by dismissing three categories of misstatements in this action. One deals with whether or not there was an actual contract signed between K-12 and Miami-Dade. The other is the capabilities of the company and the capacity of the company to implement the Miami-Dade contract and other similar contracts. And the third is their fact that their ability to counteract cyber hacks and cyber breaches. With respect to the Miami-Dade contract, the company said very clearly and unambiguously, there's a contract with Miami-Dade. They said that on August 11th, 2020, and they made it very clear. They discussed their work with Miami-Dade. They said there's a contract.
Well, they were working with Miami-Dade. That's not in dispute, is it?
Oh, that's true, but they use the word contract. And that's very important, whether or not you have a contract or not. And Barrington and investors clearly took the statement, which discusses a contract, and said there is a signed contract between Miami-Dade and K-12. And then you have William Blair saying this is a contract to win. The difference between someone doing work for somebody and somebody having a legally binding contract under the law is obviously material. You have clear, and even in particular here,
Excuse me, counsel, I thought they were just saying that K-12 was working on an agreement with Miami-Dade. I don't think that, where did they say that
There was a sign.
it had countersigned anything?
Your Honor, they say we see increase, however, in school
Can you give
districts.
us the JA reference, please?
I'll have to get you.
So we're all on the same page, so to speak. $38,
191, Your Honor.
what?
191 is paragraph 22 of the consolidated amended complaint.
Okay.
Okay, and he says in paragraph 92, which is, he says, we are seeing an increase, however, in school districts who call us and want to use our content and our curriculum with more of those contracts this year than we've ever had in any one of the year before. I mentioned Miami-Dade. There are others we are working on. There's a clear distinction. They've got a Miami-Dade contract and they're working on other contracts. And
I mean, that's one interpretation. Another way to say it is we're working on Miami-Dade and there are others that we're working on.
Well, no, because what they say is they mentioned Miami-Dade. There's others they're working on, not yet disclosed. That there's Miami-Dade and there's others that they are working on. The market, obviously, Your Honor, we can debate what was meant and how it should be interpreted. The market clearly interpreted that this was a contract that was signed. Barrington Research said signed contract. William Blair says signed contract. And this circuit is clear. It's not what the speaker's intent is. It's not what this court might interpret these words to be. It's what the market interprets these words to be.
Well, wait, I certainly understand that when it comes to whether something is material, the primary instinct is what the market would or likely did. Have we said that we let counsel's argument about the market decide whether the statement was false or not?
Whether it's misleading, yes.
Okay.
Whether the statement is misleading to an investor, the market decides that. Clearly, the market has decided. Barrington Research said sign contract. William Blair says sign contract. There could have been a correction the next day by K-12 and said, hey guys, we know you thought it was signed. It's not signed. They never went ahead and tried to correct the market. And that's particularly important here because they were not only was it not signed, they were not paid. It's very nice if someone goes to my windshield and starts scrubbing it and says, well, I work for Mr. Lieberman. He's got a great car over there that I scrub his windshield. I never paid him. I never signed it.
Was the contract included in Miami-Dade's school board reopening plan? That's what your opposing counsel says, that they actually said that they were providing services to Miami-Dade, and the fact that Miami-Dade later became dissatisfied with the quality of those services was, that may be a future event, but at the time that the allegedly misleading statements were being made, weren't they providing services to Miami-Dade, and didn't Miami-Dade include the so-called contract or whatever in the school board's reopening plan? I mean, things were pretty far along.
There may have been discussions, but when you don't have a signed and executed contract, we're all lawyers here. That's clearly a material fact, particularly when they had not yet been paid yet. And not having a signed contract actually made it much easier for Miami-Dade to ultimately not pay them. There's nothing on the record that says that K-12 ever made $1 on these services because there simply was not a signed contract. And that's even more important when there had been a $1.57 million payment to the superintendent, to his charity, at the same time that there is an unsigned contract hanging over the head of
Lieberman, can I go back to
K-12.
something you said in response to one of my earlier questions? What authority from the Supreme Court or this court says the market decides whether something was misleading?
Sure. Your Honor, Paradise Wire and Cable Defined Benefit Plan versus Weil, 918 F3rd 312. Quote, whether a statement or omission is materially misleading depends on the perspective of a reasonable investor.
Wait. Whether a statement was materially misleading depends on the perspective of a reasonable investor. And that makes total sense, that materiality is all about what the market does or doesn't care about. It says materially misleading. What authority do you have for the proposition that whether a statement was false or misleading at all is determined by the market?
Your Honor, then I would cite to Burson versus Applied Signal, a Ninth Circuit case, 527 F3rd 982. And the question is whether or not the statement gave a reasonable investor the impression of the state of affairs that differed in a material way from the one that actually exists. It's the perspective of the investor, not this court.
But it's the perspective of the hypothetical reasonable investor, like the reasonable person in tort, not here's a document that shows what someone may have misinterpreted it as saying.
But Your Honor, two analysts who are covering the company and with the stock price going up are saying that there's a signed contract. There's no signed contract. They're not even getting paid for their work. And there's a $1.57 million payment made to the superintendent while that contract has not been signed. And the work has ultimately been rejected and unpaid for. To say that all of that all bears upon whether or not there's an executed contract. And to be in a scenario where we have evidence that the market interpreted this to be a signed contract, where we all know what the importance of a signed contract is under law, and to say that this is just some immaterial fact to investors at this stage of the pleadings, we think that would be inappropriate. And there is no discussion of these facts and these details in the district court's order. It's simply the court said it's just too generalized, the allegations. These are very specific allegations as to whether or not.
One question I had was whether the Securities Litigation Reform Act and the Telabs case, which seemed to speak to a pleading standard, they required that the culpable, that the fraudulent explanation be, with respect to Sienter, be as compelling as a reference of non-fraudulent intent. And I'm just wondering, given the fact that these negotiations between these two parties had at least proceeded a good way down the road, even if the ribbon hadn't been tied up at the end. After the Telabs case, is the inference of Sienter as cogent and compelling as a non-fraudulent interest, given the fact that they have had an extensive series of dealings that Miami-Dade was utilizing services of K-12. I mean, it just seems to me that it's a more difficult case to press after Telabs and the standard announced by Congress in the Securities Litigation Reform Act.
Your Honor, we do think that under Telabs, the inference is a culpable inference, and it has to be just as compelling. The tie goes to the plaintiff, whether or not there's a culpable inference or a non-fraudulent inference. Here, not only was there an unsigned contract, first of all, Davis admits that he knew the contract was not signed. He admits that in his testimony to the OIG, or his statements made in the OIG report. So when you have someone making a knowing false statement, right away, you get that inference of scienter. But even, let's look at the facts around it. You've got an unsigned contract with a $1.57 million payment made to a private charity or the personal charity of the superintendent. And there's no signed contract. Clearly, one can make the inference is that was being done to induce the signature of that contract. And so when you look at that in context, that Davis knew it was not signed. That's right away. That should be game over under Singer versus reality. When you know you're making a statement and you know that it's undercut by that it's false and misleading, and you know about the adverse facts that undercut that statement, the win goes to the investor. That's one.
In evaluating scienter, one of the things you look at, I think, is whether the defendants personally profited from any kind of misleading statements, and did any of the defendants unload their, did they unload their stock or during the relevant period? Did they personally benefit in some way through a sale of stock motivated by information that they hadn't really signed, they hadn't really finalized a contract? I mean, was there personal benefit in this for them?
No, Your Honor, the benefit was that this was a turnaround plan for the company, and for the company to get its stock price from minus 57% that it was in the year before.
Okay, but did the representation cause a rise in the share price that defendants took advantage of by selling the shares? I'm just asking informationally, if there was a sale of shares right before the termination of services took place. Did they sell them?
No, Your Honor, they did not sell. But Telabs is clear, and other circuit courts are clear. That is not what's required. That is one way to make a culpable inference. The other way is knowledge of the falsity of the statement, and we plead that here. And the other way is other factors that show a culpable intent, particularly the $1.57 million unprecedented donation by K-12 to the person.
All I'm asking you, counsel, all I'm asking you is whether it's relevant that they did not. Presumably, the contract. Your theory is that the contract or caused the price of the stock to rise, and at least it seems to me relevant whether they profited from that by unloading some of their stock or selling some of their stock. Is there any of that self-dealing? Is there any of that self-dealing present here?
Your Honor, there's no allegation of insider sales. We would submit based upon Telabs, based upon Fourth Circuit precedent. That's simply not required. We didn't have that. That
But
was not
isn't it relevant?
reality. What's that?
Isn't it relevant? You'd have a much
Oh,
stronger.
it could be one of the factors. Meaning there's a number of factors a plaintiff can use to plead scienter. One of them is knowledge of falsity. We've pled that.
I understand.
Bad acts, we've pled that.
I'm
Another
not
way-
disputing that. Excuse me. I'm just saying, you do admit that this is definitely one of the factors.
Your Honor, it's a factor considered by the courts. It's a factor considered by the courts. Motive and opportunity is a factor considered by the courts. There are some other areas of falsity. I could address them on rebuttal, or I can handle them now.
You've got some rebuttal time, counsel.
So I'll handle. Okay, thank you.
Thank you. All right, Mr. Wald, I think it's your time up.
Thank you very much, Your Honor. Peter Wald, Latham and Watkins, on behalf of the appellees. I think I'd like to start in view of Mr. Lieberman's address.
Can you kindly speak up for me, please?
Sure. Is that better?
That's better. Thank you so much.
Thank you. I think I'd like to start with two things: the actual language of Mr. Davis's statement, which has been challenged, and also a timeline of the events, which I think really helps to put all of this into perspective. Let me start, if I may, with language. Mr. Lieberman quoted from paragraph 43, which is at JA 21, and it concerns the August 11th statements. There are two of them challenged in the complaint. The first paragraph is statement 13. As for school districts, more and more of them now plan to use online learning as an alternative to in-person classes. One such school district is Miami-Dade County Public Schools, a district we've had a relationship with for more than a decade. First of all, nothing in that preliminary paragraph says anything about a contract, let alone an executed contract. Second of all, nothing in that paragraph is false or misleading. Miami-Dade and K-12 had a very rich and successful history working together for over a decade before the pandemic. Then if you go down to the last paragraph under the ellipses, this is statement 15. What does Mr. Davis actually say? He says, quote, "We are seeing increase, however, in school districts who call us and want to use our content and our curriculum, with more of those contracts this year than we've ever had in any one year before, period. I mentioned Miami-Dade, comma, there's others we're working on, comma, not yet disclosed, but maybe not as large as Miami-Dade." Mr. Davis does not say.
Well, they're not, I think that the plaintiff's counsel is not saying that this was outright a misleading statement. The plaintiff's and appellant's counsel seem to me to be saying it's implied that a contract may not have said we have a contract, but Mr. Lieberman's argument was that, well, true, but it's implied. What do you say in response to that?
I think what is implied, Judge Wilkinson, by the statement is that the parties were working together with an understanding that Miami-Dade was going to purchase K-12's products and services. I don't think there's anything here which implies that he said that there was an executed contract. There was one analyst who talked about a contract. William Blair did not say, contrary to Mr. Lieberman's statement, that there was an executed contract. But I think what's important is to understand the background of statement 15. And I'd like to put into the record the following timeline with Your Honor's permission. On July 6, 2020, the Florida Department of Education issued guidance on educational requirements for the 2020-21 school year. That's at JA 478. Miami-Dade immediately saw a temporary learning management system, LMS, provider. The OIG report found that Miami-Dade held off developing the specifications of the temporary LMS pending the publications of the state's guidance to Florida school districts regarding the educational requirements and funding for the 2020-21 school system. So they were behind the 8 ball. That's at JA 478. Between July 6th and 10th, 2020, the OIG report says the following. Within days of the Florida DOE guidance, Miami-Dade began contract negotiations with K-12 and began the process of trying to set up the platform, integrated systems, train personnel, and roll out the temporary LMS in time for the first day of school. That's at JA 484. And the first day of school, Your Honors, was August 31st. On July,
Is your position stronger on scienter than on falsity?
Your Honor, I don't believe, well, I do believe that our position on cyanar is compelling. And to use the framework from Telabs, there were no stock sales, as Your Honor pointed out. And there were, and none
There
of
wasn't even, there were no stock sales at all. That's important to me as to whether there was a rise in the price of the stock that the defendants took advantage of with a sale of shares to their personal enrichment.
right.
That
And-
makes this a totally different case.
And Mr. Lieberman concedes that there is no such allegation, Your Honor. He tries to substitute for it a sinister spin to the donation that was made. That was the subject of the OIG report. And as Your Honors know, the OIG report found no wrongdoing. So on July 10th, Your Honors, K-12 and Miami-Dade reached an agreement on price and began to draft the agreement. That's at JA 489, the OIG report. On July 29th, the Miami-Dade administration at a special meeting of the school board advised the board of its intent to use elementary and secondary school relief funds for the purchase of the K-12 temporary LMS. That's at JA 487 and JA 347. On July 30th, the next day, Miami-Dade submitted its reopening plan to Florida DOE signed by the superintendent, Mr. Carvalho. That's at JA 381. The plan specifically states that, quote, the district is supplementing the resources provided to classroom teachers with a full complement of Florida-specific, FDOA-approved digital courses provided by K-12 Florida. On August 10th, 2020, K-12 signs the contract. That's at JA 394. The next day, on August 11th, Mr. Davis makes the statement 15, that the plaintiffs allege was false and misleading. He certainly doesn't say much, if at all, about a contract. He certainly doesn't say that the contract had been signed the day after he signed the contract by the superintendent. On August 21st, according to the OIG report, so now 10 days after the statement at issue, Superintendent Carvalho, for the first time, became concerned about reports that he was receiving from his staff and decided to void and forbid the release of a contract with his electronic signature affixed to it. And I forgot an important date, Your Honors. On August 17th, Superintendent Carvalho countersigned the contract. He didn't return it to K-12, but there's no question that he countersigned the contract. That's at JA 394. He advised on August 21st that the contract should not go out unless it had his original ink signature. And he believes that after he told his staff not to send it out, that they then added void to all pages of the report. In the period August 21 to 24, Superintendent Carvalho continued to receive reports of growing concerns regarding the statement of work and deliverables following a series of Zoom meetings with K-12 and Miami-Dade staff. That's at JA 490. On August 25th, the Miami Herald quoted the school board vice chair as saying, quote, "There are areas of planning and execution relative to training and new systems that fell below the expectations we set as a board and for which employees and parents look forward." That's JA 40. The next day, CBS Miami article quoted the teachers union president as saying, quote, "The training for K-12 has been ineffective." That's JA 41. And on August 31st, there's the first day of school. Just a couple of more dates that we think are important for the court. On September 2nd, Miami-Dade School Board convenes a meeting where it's allegedly revealed that Superintendent Carvalho never signed the $15.3 million no bid contract with K-12. The OIG report indicates that in their interview with Mr. Davis, he said that he found out about the non-signature sometime before the start of school. So he makes statement 15 on August 11. He finds out that it wasn't countersigned sometime before August 31st. Not that they intended to walk away from it, just that it wasn't countersigned. There's no allegation as to when that occurred, but the reports of problems don't begin to surface until August 21 to August 26. On September 5th or 6th, according to the OIG report, Mr. Carvalho communicated the concerns and the decision to discontinue the service for grades 6 to 12 to Mr. Davis. That's according to the OIG report, September 5th or 6th. That's at JA 502. And on September 10th, the Miami-Dade School Board voted to terminate the $15.3 million contract with K-12. Those are the facts in the record. None of that, Judge Wilkinson suggests that when Mr. Davis spoke on August 11th, the day after he signed the contract, that he made a material misstatement about the state of affairs. He did not say that there was a fully executed contract. He did not talk about a contract, and he did not imply that. What he did imply was that the parties were working in good faith and at record speed to try to be ready for the August 31st opening date. And there's no dispute in the record. The OIG report is clear that Miami-Dade and its officials were completely involved in that and were working side by side 24
But what you're saying is that what you have here is not something that was manufactured out of the blue or whatever, but that there was an extensive working relationship and history of negotiation between the parties, and that one of these parties had a track record in serving schools with this kind of remote education, and that Miami-Dade was definitely interested, and that they actually, I think they referred to it in one of their reopening plan. But these are people that are working in what they hope will be a mutually beneficial relationship. And your point, as I understand it, is that that's not enough to make a compelling, to draw a compelling inference of a scienter that the innocent explanation is at least on a par with any kind of culpable explanation. That's sort of in a nutshell where you are, isn't it?
It's a very good summation, Judge Wilkinson, and we certainly agree with that. I would add to it that the facts that I've just recited are incompatible with a claim of misrepresentation, given the actual words that Mr. Davis used. There's no question that there was a contract on August 10th. There's no question that he signed it on August 10th. He makes his statement on August 11th. As I indicated previously, the school board had already advised of its intent to use and to purchase and use K-12's temporary LMS. That's at JA 487 and JA 383. And that's at the end of July. So so to say that they're working on something with Miami-Dade on August 11th, with everything that he knows, there are no facts alleged that would render false and misleading the actual statement that Mr. Davis made on August 11th. Now, certainly it's true that problems arose after that. And certainly it's true that the school board voted to terminate the contract on September 10th, weeks after Mr. Davis spoke. But the fact that you have a subsequent event which alters the course of the party's relationship does not mean that what was said on September 11th was false or misleading. And Judge Wilkinson, because I know you're very focused on the Cyanar issue, I do think that it's important to note this court's decision in McGuire Financial, because even if you could say that Mr. Davis knew that what he was saying was not technically correct, to use the language of that case, and for all the reasons I've said, I do not believe that there is any basis to so conclude on this record. The record shows.
Well, I think you're suggesting, it seems to me that if that fall and Cyanar there's an interrelationship, but if something is not false, it becomes almost very, very difficult to prove Cyanar with a statement that was not false. But just assuming, even if we were to assume that he made a statement which you say he did not make, that he never made, that there was a contract, there's still Cyanar is still a higher bar. Even if there was a false statement, you have to show a culpably false statement. So while there's a relationship between the two, there's also, it seems to me, based on TELABS and based on Congress's legislation, the Cyanar is still something in addition that has to be tackled.
That's absolutely correct, Judge Wilkinson. And the court in McGuire made that point. And if I may, I just want to read this for the court's benefit on page 548. The PSLRA reflects Congress's determination that liability for securities fraud should not be predicated solely on an overly optimistic view of a future which may, in fact, encounter harsh economic realities down the road. McGuire Financial must show that Hinton affirmatively sought to advance or calculatedly sought to obscure that reality. The inference that Hinton may have knowingly misspoke alone does not do so. So even in a situation where the court was willing to entertain the notion not only that he misspoke, but that he knowingly misspoke, or at least knew that there was a technical incompatibility in what he said, even that is not sufficient to show Cyanar. And Your Honors, that's consistent with the discussion that this court engaged in Cuzzarelli, where the court noted that it would have been crazy, my word, not the court's, it would have been crazy for the pharmaceutical company to tout a clinical trial that it knew was going to fail, where the plaintiffs had alleged that the clinical trial was the most important product in the pharmaceutical company's line of products. Why would you tout something that you know is going to fail? Why would Mr. Davis tout the Miami-Dade relationship on August 11th if he knew that it was going to fail 2 weeks later? It makes no sense. And to the Telabs point, Judge Wilkinson, that's why the inference that Mr. Lieberman would have you draw is neither cogent nor compelling, and certainly not as compelling as the innocent inference.
All
Thank you.
right, thank you, sir. Mr. Lieberman, you have some rebuttal time that you've reserved.
Yes, thank you, Your Honor. To address a few of Mr. Wald's comments, first of all, as far as the OIG report, the OIG concluded that there's no doubt that this solicitation for gifts totaling over 1.5 million on the eve of the temporary K-12 LMS go live with an unsigned contract hanging over it created the appearance of impropriety. Whether they made a formal finding of censure or sanction, no, but it created the appearance of impropriety. Why is K-12 giving $1.5 million to the personal charity of the superintendent when there's no signed contract yet? And at least tell investors that you're doing so when you're discussing this contract. But what I would look at, Your Honors, is that even Mr. Wall's recitation of the facts demonstrates the importance of whether or not you have a signed or unsigned contract. Mr. Corvello looked at the contract, purposefully waited on the execution, waited on the transmittal of the contract, because he knew that this had legal import. He knew that this impacted the school district's liability and duty to make payment on this work, and therefore he held back on making a formal signature, and he held back on sending that signature back to K-12. That shows exactly the importance of whether or not a contract is signed versus unsigned. I find it funny and I find it interesting where you have a scenario where there's a unsigned contract, but we know how important signing a contract is. An unsigned contract is not binding. A signed contract is binding. So all that is quite important. We didn't have a chance on my opening remarks to discuss the other avenues of liability and falsity. At the same time that there was no signed contract, K-12 was making statements regarding how it was servicing Miami-Dade, and it was able to service similarly large school districts in addition to Miami-Dade based upon its technological capacities. At the time that the company is touting its capacities, you have CWs and you have internal comments made to the executives of K-12 saying, you don't have the ability to go ahead and execute this contract. You're doing this in 6 weeks. It's going to take you 6 months. According to CW1, it was going to be $6 million. They were advised, Davis was advised that it would be a $6 million investment to get K-12, to get Miami-Dade up and running. That was impossible to do in a 6-week time span. That was never. At the same time, the company was touting the contract, or the
one point that Mr. Wald was making was that the collapse of the business relationship, or the disappointment of Miami-Dade with the services that K-12 was provided, that all of this occurred after the August 11th, or whenever the date of what you allege to be the misleading statement. Isn't that another factor? The fact that the relationship collapsed. He had no idea before August 11th that the things weren't going to work out, and a lot of businesses don't. But what the Miami-Dade's disappointment, it seems to me, occurred after the statement that you take issue with, and that would make it, it seems to me, a different case than the business, than Mr. Davis knowing beforehand that the relationship was not going to pan out. As I read the record, both parties, as of the time of the statement, were optimistic that a fruitful relationship would materialize.
But Your Honor, that's not supported by the record. The allegations of the complaint make clear that Davis was warned internally by other executives and by other personnel in K-12 that this contract could not pan out. They could not get themselves ready in 6 weeks to support and service 270,000 students. They didn't have the capacity. Total view did not work. They didn't have the video did not work. They did not have the bandwidth. That's testimony by CW1. That's testimony by CW3, CW4, and CW5. And so the testimony in this action is that, and the allegations are that the company simply never had the bandwidth to support a 270,000 student district, and those allegations need to be credited. They are on the record, and they say that TotalView, the main operating software, proprietary, did not work, did not function, could not support 270,000 students. You have others saying that the training was completely and wholly inadequate. CWs 4 and 6 make this testimony.
Well, you know, every kind of business relationship, contractual relationship, whether it be construction or school services, they very often encounter bumps along the road. And the parties, sometimes they can't work it out, but other times, you know, that they are. This was a situation where the parties were hopeful, but I've never seen one of these contracts that over a period of time didn't encounter some glitches or bumps, and you try to work that out.
Your Honor, it's not bumps on the road. The car didn't work. K-12 simply didn't have the capacity to support 270,000 students. You have the Beaufort County, the same exact time, saying that that the systems did not work, that they did not have the bandwidth to support their school district. You have CW5 saying that the Tennessee Virtual Academy also didn't have, K-12 did not have the bandwidth to support the school district. You have K-12 simply cannot get the work done that they're purporting that they can get done. And they're making statements at the time that they're implementing this contract, that we are servicing K-12, that we are.
I hear what you're saying, but it's also true that K-12 did have a track record in this field. It was servicing a large number, over 1,000 school districts. I know what your response is, that there wasn't any. This was larger than those other 1,000 school districts, and you know, I hear that, but they're not. You know, they do have a track record, or at least they have experience. But at any rate,
they never had a track
time
record.
is expired. Go ahead and make a concluding statement, counsel.
Sure, Your Honor. They never had a track record for a county like this. There were multiple internal warnings saying that the company could not handle the contract. On his own, Davis reflects and says, I knew it was a risk. I couldn't get it done in 6 weeks. And it likely would have taken 6 months. He knew about the risk, but he didn't tell investors that there was a risk he could not get it done. And he needed to.
All right. Thank you, sir. We appreciate it. And I think we will now move into our last case.
It please the court. I'm Angie Bawalda for the appellant. The overriding question regarding this case is whether a court of the Commonwealth of Virginia would see fit to recognize the marriage of the appellant, Michael Edjay, and his wife, Barbara Bletting, who have now been married 21 years. Or would they instead find that Michael's wife is a criminal, a bigamist, and his 4 children are illegitimate? This all stems from Mr. Edjay's application for naturalization, which was denied by U.S. Citizenship and Immigration Services and by the district court because his wife, Barbara Bletting, and her ex-husband, Kingsley Gaisa, were not domiciled in Ghana at the time of their divorce, and which was ceremonially dissolved by the responsible elders of the 2 families on January 6, 2000. This denial by USCIS and the district court occurred despite the fact that Barbara and Kingsley were originally married in Ghana under customary tribal law. The fact that they lived together in marriage in Ghana for several years, the fact that they both continued to have their citizenship in Ghana at the time of the divorce, and the fact that the dissolution of the marriage followed the same strict protocols of the Ghanaian traditional law. Through no fault of his own.
Are there any Virginia appellate courts recognizing a divorce issued in a jurisdiction where neither spouse was domiciled?
So the Virginia appellate court case of
First, I'm happy to hear about the case. Is there such a case?
no, Your Honor, not a Virginia appellate case. There are potentially 2 Virginia cases that did recognize it, and I would argue that in the Virginia Fairfax County case of El Khari v. Atum, that it had a few analogous facts, including that the couple there was married in their native Jordan and lived there together for a brief period of time, and the fact that neither were domiciled there at the time a divorce decree was obtained. Then the facts deviate from there. In El Khari, the U.S. citizen husband sought the divorce from Jordan in order to shorten the qualifying period of separation required in Virginia to obtain a divorce. Again, he was the U.S. citizen. He utilized a power of attorney in Jordan to file for divorce there, and he did not give proper service to his ex-wife, but posted the notice on the parents' home in Jordan. This amounted to a unilateral divorce. It is significant to note that in addressing domicile, the judge in El Khari v. Atum of Fairfax County analyzed additional public policy considerations. Domicile is addressed as a subsection of Virginia public policy. The court identified whether there were some reasonable residency and domiciliary requirements as one of the multiple issues. Reasonable means that this is not a simple yes-no equation, and that domicile is not a mandatory prerequisite to granting comity. The judge looked to domicile arguments with the same weight as the notice requirements and the waiting period requirement. In contrast,
but as it count as you say there may be a trial court, I don't know, it may or may not be, but although they are all older cases, the Evans case and the Howe case both seem to indicate that recognizing a divorce decree as a matter of comity depended on whether they were both, wouldn't do it when neither spouse was domiciled in the divorcing jurisdiction. And as far as I can tell, neither Evans or Howe has been overruled. And as a federal court, don't we owe a particular deference, well, not only to state law as a general matter, but when you're talking about marriage and divorce and family law issues, don't, and we're talking about comedy, don't we need, as a matter of comedy, to pay particular attention to the strict dictates of Virginia law?
Your Honor, all of the cases that you've referenced and that opposing counsel referenced in their briefings all involve male actors. It all involved a dispute between one of the parties to the divorce. And the distinction, and I believe it's a key distinction, is that the case at hand, as well as other cases, demonstrate that in here, we don't have an issue of one of the parties to the divorce disputing it. Kingsley and Barbara had agreed to the method of divorce, and therefore they never disputed or challenged the method of divorce. And that's a key distinction from the other cases that you reference and that opposing counsel reference.
Well, can I come from this? I take your point on that. And we look at this in a somewhat different way. Aren't you asking us to do something that is not generally recognized? In the United States, I think there's only one jurisdiction would do this. Isn't that correct?
Your Honor, in New York, that is the jurisdiction you're referencing, but here in Virginia,
Well, is there another jurisdiction? Let's leave aside both Virginia, that I know you're arguing about, and New York, which I acknowledge. Is there any other jurisdiction in the United States that would do this?
Your Honor, the issue on comity is one that we've been reviewing here, and the issue is not found in the same way in other jurisdictions.
So the answer to my question is no. Is that correct? There is no other jurisdiction besides New York, and what you're proposing that we do here is Virginia law.
We were unable to find another jurisdiction with a similar fact pattern. The point that we're
Well,
making.
do you find another jurisdiction with a dissimilar fact pattern, but which comes to the same conclusions? Some other facts are different.
Your Honor, there aren't other cases in other jurisdictions, no.
Okay.
Your Honor, looking at the issue of comity, the U.S. Supreme Court, in its decision, Hilton v. Giat, had defined comity as, quote, the recognition which one nation allows within its territory to the legislative, executive, or judicial action of another, having due regard both to international duty and convenience and to the rights of its own citizens or other persons who are under the protection of its laws, unquote. The plain meaning of the words in this definition and the standard of recognition must take into account multiple considerations of public policy and public well-being. For example, the 4 EJE children are under the protection of the Commonwealth of Virginia, and their rights must also be factored in and considered. In Hilton, the court stated, quote, a judgment affecting the status of persons, such as a decree confirming or dissolving a marriage, is recognized valid in every country unless contrary to the policy of its own law. The court went on to say that, quote,
Counsel, you just mentioned another country, and I want to ask you a variation of Judge Mata's question. I know there are cases about U.S. citizens who move from one state to another. I want to bracket all of those cases. I want to ask you this. Are you aware of any case in which the highest court of a state refused to recognize the divorce of 2 citizens of that country in situations where the marriage had also been performed in that country?
Your Honor, I am not aware of such a case with those specific facts, no.
And isn't that important? I mean, I guess because, you know, domicile matters a lot for U.S. citizens because if you say that I'm a citizen of Virginia, that just means I'm domiciled in Virginia because there's no separate test for state citizenship other than domicile. But all kinds of people are citizens of countries in which they're not domiciled, right?
They are, but in the context of divorce, when you're looking at—
Sorry, this is a friendly question.
Yes, when you're looking at the divorce rules or traditions of another country, comity requires that the state which is analyzing give consideration to that country's safeguards within its statutory or traditional, in this case, traditional.
Right. I mean,
customs.
it's one thing for me to say that a Virginia court would not recognize a divorce if two Virginians run off to get divorced in, say, Nevada, I could imagine why Virginia might say, we're not going to recognize a Nevada divorce of two people who don't live in Nevada. That, I can see that argument. It's quite another thing to say, to predict that a Virginia court would not recognize a Ghanaian court's divorce of two Ghanaian citizens. That seems like a whole different thing.
Well, correct. And these were both citizens of Ghana, and they exited their marriage in the same way they entered in, under traditional Ghanaian law. And it's our viewpoint that a lot of the cases that do look at Nevada or other situations where the one of the parties had gone there to get the divorce, they were doing that to flout the law. So in this case, and also the case of Anand v. Lynch, there was no flouting of Virginia law of any kind. In fact, the safeguards are stronger under Ghanaian traditional law than even here. In Ghana, you cannot get a dissolution in the traditional custom without the family. You don't get married in Ghana without the family. It is the elders of the tribe or the family that actually participate in the ceremony. It's the same with the dissolution. It's the elders that participate in the ceremony. Even had Kingsley and Barbara obtained their divorce in Fairfax County, nevertheless, they could have received it. They weren't flouting the law in any way of Fairfax or of Virginia. What they did was go to Ghana and relieve the duties of their tribal traditions through the elders who were there. Now, Your Honor.
So building on my colleague's question, does, and taking your point, is there anything particular about having the two people not be within the jurisdiction of the group, the state or the country that is supposedly granting the divorce? Is there any particular careful look a subsequent court is entitled to give to that kind of divorce?
Your Honor,
it seems to me that you could make the argument that that is more, I understand it wasn't susceptible to abuse here, that there was no abuse, but it is more susceptible to abuse, right?
so in the context in Ghana, you have to have the elders of the church. I'm sorry.
I
of
do
the
understand
tribe.
that, and I think
Yeah.
that's a good argument. You've made it already.
Yeah.
I'm asking you to take this because then what we establish is a rule here, not just for Ghana divorces, but for other countries, right?
Well, it may be that the domicile point is a point of public policy, but it's not the only point.
Right.
And our position is that there are other public policy considerations. I would turn the court's attention to the Virginia Supreme Court of Owell v. Owell, which granted comity there to a family court situation where they looked at the standard of care given in England to a custody of the children in that case. And the Supreme Court of Virginia found in Owell v. Owell that the standard included societal values, personal rights, and public policy, which is reasonably comparable. And that reasonably comparable language is also language which was found in the case of R.E.V. Atum. They're looking at the reasonableness. And
this is one of the questions that I wanted to ask you, Ian. What is the limiting principle to your position? I mean, where do we go from here? You're attempting to build an equitable case, I recognize, but if we throw out the idea of the one spouse needs to be domiciled, what do we put in its place, and what authorization does Virginia law give us? Because I think the argument you make before is this is an appealing, equitable case, and I'm not disputing that, but I don't know as a matter of law what we have to recognize as far as when Virginia must recognize a divorce decree as a matter of comedy. I mean, I just don't know where we go once we depart from whatever drawbacks seems to be something of a bright line rule, a workable rule.
A couple of points there. We don't believe that it is an exclusive requirement that one party of a divorce be domiciled in the jurisdiction of the divorce.
Excuse me, when you're answering that question, can you tuck into your answer a response to how versus how, which seems to be a statement by the Supreme Court of Appeals of Virginia?
Yes, Your Honor.
Which said each state has exclusive control of the matrimonial status of those domiciled within its borders.
Yes, Your Honor. 2 points on that. First of all, I would like to point out the Supreme Court case of Hilton v. Guyot had an additional important principle, and that is, quote, "It is against the law of nations not to give credit to judgments and sentences of foreign countries till they be reversed by the law, and according to the form of those countries wherein they were given. For what right hath one kingdom to reverse the judgment of another?" That's Hilton v. Guyot, 1885 U.S. Supreme Court. So they're looking at international comity there. And I would say with regard to the issue here in Virginia, you have the principles set forth in, for example, Humphreys v. Humphreys, as well as Clark v. Clark. Again, you're looking at broader public policy issues, including duty, mutual interest in reciprocity, courtity, convenience.
Well, see, that's the problem. You're just substituting a multi-factor test, and that we have some sort of equitable exceptions to the domiciliary requirement. And I don't know what we're doing. Are we gonna, you say they got divorced in accordance with tribal customs? I mean, are we, a court, supposed to go fishing around each country's tribal culture? I mean, we're substituting what respectfully seems to me to be an indeterminate and somewhat mushy standard for what appears to be clear Virginia law in an area of domestic relations where it seems to me that state law occupies a paramount place. And I'm always nervous in establishing equitable exceptions to this and that and the rest, not only because they're very hard to apply and they're vague, but they lead to inequities. Some people get the advantage of the equitable instincts of the court and others don't. And I feel like we're sort of sailing into never land. But at this point, maybe the best thing to do is to ask Judge Motz or Judge Heitens if they have questions of you, and if they do, then that's fine, and if they don't, you'll have some time for rebuttal. And I'll ask my colleagues if they want to ask you a question.
Thank you, Your Honor.
We thank you. Ms. Yang, be a pleasure to hear from you.
Thank you, Your Honor. Good morning, and may it please the court. Catherine Yang from the Department of Justice. I think it might be helpful to start at the beginning with the discussion of what comedy is and what comedy is not. Comedy is not about whether the foreign jurisdiction would consider the divorce valid under its own laws. Comedy is about whether to recognize the divorce obtained under foreign laws, applying, in our case, Virginia's laws. and for the purpose of which we are appearing before the court today, with the additional nuance of doing it for purposes of immigration law, naturalization law. As this court held in the Jahed case from 2006, the framing of the issue is whether for purposes of United States law, the foreign jurisdiction had power to enter the divorce, not whether the foreign jurisdiction under its own laws had power to enter the divorce. And here, Virginia law is clear. For the last 100 years, the Virginia Supreme Court has held that domicile is the controlling question when determining whether or not to recognize a foreign divorce as a matter of comity.
Ms. Yang, I've heard it's very clear they've said that in the context of US citizens, where domicile is the sole test of citizenship. Do you know of a single Virginia appellate decision that says domicile is the controlling inquiry when the person is the citizen of a foreign country?
I will acknowledge that I believe all of the appellate decisions from Virginia arose in the context of intrastate recognition, meaning intrastate within the United States.
And isn't that a super big difference for at least two reasons? One, if it's state to state, it's a full faith and credit issue, not a comity issue. That's difference one. And difference two, again, as I said with your colleague, there is literally no, I mean, I grew up in Wisconsin. I feel very attached to Wisconsin, but I am not in any sense a citizen of Wisconsin because I am domiciled in Virginia. And under US law, I can only be domiciled in one state. And the notion of being a citizen of a state, a US state, without being domiciled there is literally gibberish, legally speaking. There is no test for what it means to be a citizen of Virginia other than to be domiciled in Virginia. That is not true for national citizenship, right? The stats I see are there are 9 million US citizens living abroad. And I think the United States would take the position those people are still citizens. They have to pay taxes in the US. They do all kinds of things in the US. So why isn't that just a gigantic difference? We're not talking about two people who were citizens of Alaska and got married in Alaska and got divorced in Alaska. We're talking about citizens of Ghana who got divorced in Ghana. And the question is whether Virginia would recognize their Ghanaian divorce.
Right, so I think there are a few pieces to the response to your Honor's question. The first is just to quickly address the full faith and credit versus comity issue. Certainly full faith and credit is at issue when it is state versus state law. But nonetheless, comity is also still discussed in those same cases. So it's not that the state law cases exclusively discuss full faith and credit. That is the floor. Comity goes above that. It is discretionary beyond that. And the many cases from the Virginia Supreme Court that we cited all have discussed the question of recognizing divorces, foreign divorces, as a matter of comity. So that's the
foreign is in the sense of other US states, not other countries.
Correct, that's correct. The second piece of my response is I would point the court to the Virginia Circuit Court decision in Alcary. Now, of course, I recognize that's not an appellate decision, but it is, I think, quite instructive, and it is also very recent. And so I think for that reason it is.
But I've read that decision, and it does not grapple at all with the difference between US states and other countries. It just assumes that distinction is irrelevant.
Right, so, but I think it's important because in that case, I believe at least one of the spouses to the divorce was a citizen of Jordan. It may have been that both were, I can't remember that particular piece, but certainly at least one of the spouses was a citizen of Jordan at the time of the marriage. The couple was originally married in Jordan, they lived in Jordan, they later came to the United States.
Oh, no, sure. I think that case is very good for you. And with all due respect to that decision, I am very inclined to think that decision is just wrong.
Certainly, I appreciate your Honor's position there. But nonetheless,
because there are circuit court decisions that do the opposite, right? We agree there's at least one Virginia Circuit Court decision that would recognize it.
So respectfully, Your Honor, I'm not sure I would agree. And the reason for that is a fewfold. So I believe the circuit court decision that you're referencing is the Bloom case from 1977. That was a circuit court decision. The first piece that I would say is that we actually don't have that case before us. We don't actually know what it said or what the facts were or what the reasoning was. So that's problem number one. Problem number two is that the only way this case came up was in a description in a law review article. When I looked back at that article, the article itself didn't actually say that there was domicile by the spouses in that case. That was an assumption, I believe, that Petitioner's Counsel made in their briefs, but it wasn't actually stated in the law review article. So that's another problem, again, because it does go against a century of Supreme Court Virginia law.
Can I try
saying
to,
the
can I try to narrow what I think is the dispute in this case? CIS originally, CIS, is that right?
Correct, yes.
Originally gave like 3 reasons for refusing to recognize this marriage in its initial decision, but then it dropped 2 of the 3, right? So any questions about fraud or mistake, all of those things are gone. Literally the only question before us now is, assuming that this marriage and divorce were conducted in strict compliance with Ghanaian law, would Virginia recognize it, right? That's the only question left. There's no question about whether tribal law, divorce, marriage is sufficiently analogous. That's all gone, right? The only question is this domicile. Is that right?
Correct, is whether for purposes of determining strict compliance with naturalization law.
Sure.
And
So I guess for purposes of that, we can assume away everything about traditional tribal marriage in Ghana, traditional tribal divorce in Ghana. We could assume this divorce was done by the courtiest court that ever was, that is identical to Virginia in every conceivable respect, right? None of the differences between traditional Ghanaian marriage and divorce and how one might get married in the Circuit Court of Fairfax is at all relevant, right?
So I'm not sure I would agree with that, Your Honor. And again, this brings me back to my domicile point, so I hope I can address them together. But what the Virginia courts do is they look at overall consistency between the foreign jurisdictions laws and the laws of the Commonwealth. And when there is reasonable consistency, such as in the Ohl case that petitioner cites, then it doesn't offend Virginia public policy to recognize that foreign divorce, certainly. The Virginia Supreme Court in the Humphreys.
But the only part of overall consistency that CIS is actually relying on at this point is the domicile point, right?
That's correct.
There's no other relevant part of consistency.
That's correct, because having domicile on the one hand and lacking domicile on the other are not slight differences. They are polar opposites.
Okay, I mean, let me give you guys, I guess, a hypo that troubles me. So I want you to imagine the following hypo. 2 Virginia citizens, 2 people grow up they're US citizens. They grow up in Virginia. They're domiciled in Virginia. They get married in Virginia. And then they move to the United Kingdom because one of them gets a job. And they're in the United Kingdom to get a job. While there, they get divorced while in the UK. The entire time they remain domiciled in Virginia, though, because they don't establish any permanent intent to remain in the United Kingdom. Is your view that Virginia wouldn't recognize that divorce? It has to be, right? Because that in the domicile point is the same as this case.
So if I'm understanding the hypo correctly, the couple maintained their domicile in Virginia throughout the entire time.
Because they failed to take affirmative steps necessary to establish affirmative domicile in the United Kingdom because they're only there temporarily for work.
And they went to England
a UK court to get divorced.
Obtain a divorce, and presumably the UK divorce granted the divorce. Because
UK gave them a divorce.
So I think the hypothetical is missing a couple facts which I think might affect the analysis. I think one key fact that's missing is whether the UK court had a domicile requirement in order to find jurisdiction for their.
Let's posit it didn't, because they granted them a divorce.
Yeah, so I think in that case, I think it would be the case that Virginia would not recognize the UK divorce, because in that instance, the procedural laws of the country in which the couple obtained the divorce are fundamentally at odds with the procedural law and the substantive law of Virginia. I believe it was the Virginia Supreme Court in McFarland that said no state is bound by comity to give effect in its courts to the divorce laws of another state repugnant to its own laws and public policy. Similarly, the Court of Appeals in Clark said it would be violative of public policy to displace our own procedural.
Okay, so let me continue with that hypo and ask you if this troubles you. So now say everything is the same except they establish a UK domicile, as in they've moved to the UK. They're now living in the UK. So again, the hypo is 2 people who meet in Virginia, grow up in Virginia, get married in Virginia. And when they get married in Virginia, they're absolutely domiciled in Virginia. They move to the UK, they establish UK domicile. Some number of years later, things don't work out. And they think, we got married in Virginia, we should probably get divorced in Virginia. So they go back to Virginia and get the divorce there, except, they're not domiciled in Virginia at that point. And so when they go back to London, the UK refuses to recognize their divorce. you think the United States would be terribly happy with that outcome if the United Kingdom refused to recognize a divorce of two US citizens of a marriage that was contracted in Virginia, that was dissolved in Virginia on the grounds that they live in London at the time the marriage was dissolved?
I don't think I'm in a position to say whether or not the US government would be happy or unhappy in that scenario.
Bold move to say, forget you, Virginia court. I know you created this marriage. I know you got rid of this marriage. I know that when you did this marriage, it was perfectly lawful, but we, the courts of the United Kingdom, don't feel like recognizing that because they're in London now and they're ours, not yours.
I do think that under the laws of of course, another piece would be the laws of the jurisdiction in which the subsequent marriage occurred would govern. So perhaps then we're in a.
No, but we have to assume that all the way too, right? Because for purposes of this case, as I understand, the only legal question is whether this divorce was valid. Because if the divorce was valid, then the subsequent marriage was valid. And if it wasn't valid, then it wasn't. So
if the divorce was valid for purposes of immigration law.
which you have said just incorporates the law of Virginia.
Right, not whether the divorce was valid under the laws of
Ms. Yang,
Yes. Yes, Your Honor.
the burden is on the petitioner here under federal immigration law to establish the validity of marriage and divorce. Now, is there any impediment at all or any bar at all to federal law building upon Virginia law for federal immigration purposes? Is this plainly a matter of state law? And is there any bar to having federal law rest upon a state law predicate?
No, Your Honor, because we're in this unique context of the immigration and naturalization context, for purposes of determining whether the petitioner is eligible for naturalization, we have to look at whether he's in strict compliance with the naturalization.
But do we have any other option? Do we have any option other than to rely upon Virginia domestic relations law as it pertains to marriage or divorce? We can argue about what Virginia law says, but on the underlying question, there's the only option that we have is to interpret Virginia law in terms of the validity of marriage and divorce, and that federal law can be predicated on Virginia law. And so in your argument is that the Virginia law, there may be some old cases, but Virginia's Supreme Court has spoken, and it's been clear, and the legislature and the Virginia courts have not overturned that to any discernible degree. And I guess what I'm saying is consulting state law is really the only option that we have. We can't create a federal common law of marriage and divorce for immigration purposes. We can't go the route of a federal common law test. We have to consult state law in an area of traditional state primacy.
That's correct.
That's at least how I would understand you say we have to channel that inquiry.
That's right. And I do want to make clear that there is no dispute in this case whatsoever by either party, that it is Virginia law that governs the question. And when the highest court of resort in Virginia has repeatedly spoken on the issue of what is required to recognize a foreign divorce as a matter of comity.
What is required to recognize a foreign divorce, foreign in the sense of another state? Have they ever said that in the context of a foreign country?
The Virginia Supreme Court has not, but I think the import of that legal principle.
And so what if any Virginia Supreme Court decision would be inconsistent to say we fully understand that when it comes to state comity, domicile is the test for whether you can get a divorce? but we decline to predict that the Virginia Supreme Court would decline to recognize a divorce entered under the laws of a foreign country when the underlying marriage was contracted under the laws of that country, and at when the time of both the marriage and the divorce, both parties to the marriage were citizens of that country.
So again, I can't point to an appellate court decision from Virginia that has dealt with a foreign country, but certainly when it comes to dealing with foreign divorces in the sense of intrastate divorce.
So Judge Motz asked your colleague a question then. Can you think of the decisions of the High Court of any state that have said they wouldn't recognize a divorce in that situation?
I believe that we cited to the American Law Reports relevant section in our red brief. And in that summary, the authors stated that New York was the only jurisdiction within the United States to recognize a foreign divorce, whether it was a divorce made foreign because of other states or because of other countries. New York was the only jurisdiction within the United States to recognize that divorce in the absence of domicile based on some other connection with the forum. Every other jurisdiction in the United States has done the opposite. And of course, as most relevant here, although I acknowledge Your Honor's concern with the lack of Supreme Court cases, Virginia Supreme Court cases dealing with foreign countries, the wealth of precedent that has developed in this state is that domicile is the controlling question. And Alcari, again, is a circuit court decision, but it is applying the last 100 years of precedent from the Virginia Supreme Court to hold that divorce obtained in a foreign country, even when there were ample connections between that country and the spouses to the divorce, that wasn't the relevant focal point. Domicile was the relevant focal point.
So Judge Heitens makes, my friend makes what I think is a good equitable case as to what should happen in this situation or that. And my concern is simply that we are the followers and not the leaders here. And we're just bound by Virginia law because I don't think Virginia law has bound on an has embarked on an equitable course. One of the troubling aspects of this is I don't want to get into a land of indeterminacy. And one of the arguments that was made was that they were divorced in absentia through relatives according to tribal custom, that this was a tribal custom in Ghana, that you could have an in absentia divorce through relatives. But then that lets us loose into saying, you know, going on to some sort of excursion or fishing expedition about what each country's tribal culture is. And that seems to me to be pretty open-ended.
And so I think, Judge Wilkinson, your point on equity is a good pivot point to where I'll conclude, which is—
Well, counsel, can I just ask you, under your argument, they could have gone to Ghana and it wouldn't have mattered. They could have gone to a courthouse that is indistinguishable from the circuit court. None of your argument in this case depends on this an absentia tribal law stuff, right? Because under your argument, even if the two of them had gone back to Ghana, even if the two of them had gone to a courthouse that is indistinguishable from a Virginia circuit courthouse, none of that would matter because they weren't domiciled in Ghana at the time, right?
So I'm not sure that's entirely correct, Your Honor, and let me explain it this way. So domicile is the controlling question in Virginia law, and it's a necessary element. Without it, as we've demonstrated, Virginia courts do not recognize the divorce. But let's assume that domicile is established. Once domicile is established as that—
No, let's assume it's not established, because in your view, once it's not established, literally nothing else matters.
Yes, that is correct. Once it's not established, nothing else matters. But if it were established, there could be any number of other factors that a Virginia court could consider as a matter of equity in determining, nevertheless, to not recognize, not recognize the foreign divorce, which is to say that domicile is necessary, but it may not necessarily be sufficient in the end for Virginia to ultimately recognize.
No, I understand that. I'm just pointing out that's not the ground CIS relied on.
No, that's correct. Domicile is the foundational element that is missing here. It could be that there are other ways in which Ghanaian divorce procedures either are contrary to Virginia public policy, whether procedurally or substantively. That's not an issue here because the floor that is missing is domicile.
Can I ask you a question? You didn't talk about this matter of Adwo in your case, and this is the BIA's decision, which they cite a couple of times, that a declaration could establish that a previous marriage that had been dissolved under Ghanaian customary law. Both of them were married in Virginia. Do you have anything to tell me about that case?
Yes, Your Honor. So I believe matter of Codwo was determining what's required to prove a Ghanaian divorce. And the issue here is not, again, going back to where I started, the issue here is not the validity of the Ghanaian divorce under Ghanaian laws. It may very well be that the Ghanaian divorce is valid under Ghanaian laws and within the
Even though the
boundaries.
people were married in Virginia.
Right, correct. Yes, because it is for purposes of determining divorce, we are looking at where we are looking at the validity of that divorce for purposes of recognizing the divorce. And so the issue here is not the validity of the foreign divorce under the foreign jurisdictions laws, but rather as a matter of comedy for purposes of United States law, for purposes of Virginia law, we would recognize the divorce here. And unless there are any other questions, I thank the court for its time and ask that the district court decision be affirmed.
All right, thank you. And Ms. Buvalda, you have some rebuttal time.
Thank you, Your Honors. I would point out that the U.S. Supreme Court in Hilton v. Giat did review comity in the context of nations. And I think that that's in part what's happening here. And also, I would point out that, thank you for referencing the matter of Codwo, because there's a string of BIA cases which reference Ghana. Judge Wilkinson referenced the fact that are we asking a court in Virginia to overturn centuries of precedent? And we're not. What we're asking the court to do is recognize that there are additional principles, that the principle of domicile is one, but not the exclusive principle. Domicile is important, but it's not controlling. If domicile were the controlling question, then in Acri versus Atum, the Fairfax court would have ended its discussion when it talked about domicile. Instead, it went into reasonableness. Mr. Edge's case is not seeking an exception. Mr. Edge's case is not seeking an exception to the rule regarding domicile of divorcing parties, nor are we asking for a new test. We're asking—
You seek to distinguish your instance, your case, from cases which just involve citizens of the United States in the United States.
Yes, Your Honor. And I think—
And what is your basis for doing that?
Your Honor, we're looking at it as a nation's. As the Supreme Court in the Hilton v. Giat reference, it's not for one kingdom to overturn the laws of another. We're recognizing that Ghana does have significant traditional law, and they also have within their system safeguards.
So your rule would be that if a foreign nation recognizes a divorce, its citizens, then that's all she wrote. Then every other nation has to recognize it. Is that right?
There are additional factors that should be considered. So I'm not arguing that.
Whether
No.
the foreign people were domiciled in the foreign nation?
Right, or whether there's fraud perpetrated. I would distinguish Jahed v. Acri from the standpoint, in Jahed v. Acri, there was efforts to perpetrate by the parents in that situation who were fabricating their divorce in order to qualify their son for citizenship.
I don't understand. I don't understand where you're taking us. I don't understand where you're taking us. All you've said is reasonableness. And that just seems to me to leave everything at sea. I don't understand where you're going with this. What's the new framework? You've got an older rule. Virginia might change the rule. Maybe it's wise for Virginia to change the rule. But I don't understand why a federal court should be embarking on a reasonableness standard for recognition of marriage or divorce. It seems to me that's Virginia's choice to do, and that we should sort of be the last ones to be expanding state law in an indeterminate direction. I don't understand where we're going with all of this.
Thank you, Your Honor. So the Virginia Supreme Court in America Online versus non-tie electronics, in that case, once again, they looked at comity, and they're looking at other factors, including terms of moral standards, societal values, personal rights, and public policy. Again, these are all reasonably comparable to that here in Virginia. So I think what we're looking at is not so much a test distinguishing, but a test affirming that here in Virginia, domicile is one but not exclusive of the factors under consideration. I believe the district judge in Annan v. Lynch was accurate when he ruled in favor of the Ghanaian couple in that case, because in that case, we saw that there were factors considered, and we're looking at those factors in today's case. In Mr. Ejay's marriage to his wife of 21 years and looking at the consequences, including to the children. You can't look at this in a vacuum and only look at one strict construction rule of domicile. There have to be other considerations because there are others impacted by this, namely the children, and that's as well as his wife. I mean, pardon me. We're also looking at these significant consequences of a ruling to find that domicile controls exclusively, in that Mrs. Ajay, Barbara Ajay, will be a criminal and a bigamist. Here in Virginia, that is a strict liability. Here in Virginia, the consequences are significant. They have filed tax returns. They have done everything as joint. And it isn't what she thought she was divorced. And now there'll be a court determination that she wasn't divorced properly and that she's a bigamist. These are extreme concerns for the family.
They're not saying necessarily bigamist. All they're doing is simply, as a matter of federal immigration law, is relying on state law and what seems to be a pretty clear rule. Now, you know, there's a lot of discussion about the advantages of multi-factor tests versus the advantages of a bright line rule. And a bright line rule has tough consequences in some cases, but it also has advantages in providing clear notice and in stemming inequalities, because if you leave everything up to a reasonableness test, then you're going to have all kinds of inequalities, I think, in terms of marriages that are recognized and marriages that aren't. I don't want to be repeating myself, but I don't understand where all this is going at all. And you talk about the factors in your case and about other people in your case, but we can't construct a rule out of the particular circumstances of one case. If Virginia wants to do that, if Virginia wants to do a multi-factor test, they can, but I don't think Virginia has opted for the things that you are asking us to adopt, which is
Yes, do you
is
acknowledge,
a multi-factor reasonableness test.
do you acknowledge that we are to try to predict what a Virginia court would do?
Yes, Your Honor, you're to predict what a Virginia court would do.
Well, we're
and
to
in
predict what the
clarity-
Virginia Supreme Court would do, not what some court in Virginia might do.
Right. The
Right.
Virginia Supreme Court, and I would reference that there are Virginia Supreme Court cases in the family law context, Oil v. Oil being one, and also the Virginia Court of Appeals in Clark v. Clark, which looked at factors beyond simply strictly domicile.
No,
And-
and I understand that, but we're all in agreement that we look to what Virginia law is.
And one of the things I believe that the district court in Annan v. Lynch had found, and why they relied on matter of Ma, is that there is a distinctive 3 or 4 point test given there under matter of Ma, and our case squarely fits within that. Thank you, Your Honors. I know I'm out of time.
We thank you very much. And we will adjourn court. And Ms. Walker, I want to thank you very much for being our courtroom deputy, and you've done a fine job. And we will we'll adjourn court.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.